Start. The joint subcommittees on civil rights and human services and workforce protections come to order. Welcome, everyone. I note that a quorum is present. I ask unanimous consent that Ms. Underwood of Illinois and Ms. Shalala of Florida be permitted to participate in today's hearing with the understanding that their questions will come only after members of the Civil Rights and Human Services and Workforce Protection subcommittees on both sides of the aisle who are present have had an opportunity to question the witnesses. Seeing no objection. The subcommittees are meeting today in a legislative hearing to hear testimony on H.R. 7, the Paycheck Fairness Act. Pursuant to Committee Rule 7C, opening statements are limited to the chairs and ranking members. I recognize myself now for the purpose of making an opening statement. In 1963, President Kennedy signed the Equal Pay Act, and our country enshrined into law a fundamental concept: equal pay for equal work regardless of sex. Because of this landmark law, Title VII of the Civil Rights Act of 1964, and more recently, the Lilly Ledbetter Fair Pay Act, we have made tremendous progress in reducing inequities for women in the workplace. Unfortunately, loopholes and insufficient enforcement have allowed wage discrimination to persist. The Equal Pay Act has been law for more than half a century, but in 2019, equal pay for equal work is not always a reality. Today, women earn on average 80 cents on the dollar compared to white men in substantially equal jobs. The wage gap is even worse for women of color. For example, Black women earn an average of 61 cents on the dollar, Native women earn an average of 58 cents on the dollar, and Latina women earn an average of 53 cents on the dollar compared to white men in substantially equal jobs. The wage gap persists in nearly every line of work, regardless of education, experience, occupation, industry, or job title. This has severe consequences for the lives of working women and families and for our economy. The lack of easily accessible data on wages makes discrimination difficult to detect, let alone prevent. Even when wage discrimination is discovered, working women still face significant barriers to meet the heavy burden of proof for holding employers accountable for discrimination. Not only is it difficult to prove a pay disparity between employees, identifying an employee of the opposite sex in an equal position who is paid more in the exact same physical location can be impossible in many situations. This is even more challenging when information about wages and pay raises is often kept secret, and in many cases even barred from being shared between coworkers. The roadblocks to enforcing pay equity help explain why pay inequity still exists for women, even with the Equal Pay Act. Several states have acted to address pay inequities, including bipartisan efforts in my own home state of Oregon. But it's time for Congress to address persistent wage discrimination nationwide. Today's legislative hearing will focus on H.R. 7, the Paycheck Fairness Act, a proposal to confront and eliminate loopholes that allow for gender-based wage discrimination. The Paycheck Fairness Act would require employers to prove that a pay disparity exists for legitimate reasons. It would ban retaliation against workers who discuss their wages and allow more workers to participate in class action lawsuits against systemic pay discrimination. It would prohibit employers from seeking the salary history of prospective employees, which, despite ongoing legal disputes, is in line with existing precedent. The bill would also develop wage data collection systems and provide assistance to businesses to improve equal pay practices. With this legislation, we have the opportunity to disrupt a national cycle of discriminatory pay that keeps too many women and families in poverty. And we have the opportunity to finally make equal pay for equal work a reality by passing the Paycheck Fairness Act. Thank you, and I now recognize the distinguished ranking member of the Civil Rights and Human Services Committee, Mr. Comer, for the purpose of making an opening statement.
Thank you, Madam Chairman. Women deserve equal pay for equal work. In 1963, Congress amended the Fair Labor Standards Act with the Equal Pay Act, making it illegal to pay different wages to employees of the opposite sex for equal work. The following year, Congress approved the Civil Rights Act of 1964, which made it illegal for employers to discriminate based on race, color, national origin, religion, and sex. These laws marked a seismic shift in the United States as we affirmed as a nation that discrimination cannot have a place in America. We learned the hard way that change this significant cannot and does not happen overnight. But the fact remains that while some bad bosses may have blurred the lines over the past several decades when it comes to fairness, the law has not been on their side. Economic studies conducted by government and private entities alike have consistently demonstrated that women tend to make better choices about managing work-life demands than men. If employees of different sexes are going to do the same work, they are entitled to the same pay. The American workforce is comprised of more women than ever before, 74.9 million women. Of the 2.8 million jobs created in the past year, more than 58% have been filled by women. The number of women-owned employer firms continues to rise, and census data shows that women own about 1 in 5 employer businesses nationwide. This contribution to the American workforce is profound, and it must be celebrated. All women deserve fairness and dignity as they seek greater options and opportunities in their respective careers. Republicans are committed to that future, and we will continue to focus on strengthening economic policies that affirm the bedrock principle of equal pay for equal work. Unfortunately, the legislation which is the focus of today's hearing has many shortcomings in this regard and does not help the people its authors want you to think it does. I look forward to the dialogue with our witnesses today, and Madam Chair, I yield back.
Thank you, Mr. Comer, and I now recognize the distinguished chairwoman of the Workforce Protection Subcommittee, Ms. Adams, for the purpose of making an opening statement.
Thank you very much, and good morning. I want to share my appreciation to Chairwoman Bonamici, Ranking Members Byrne and Comer, and to all of the witnesses who've joined us here today for this important discussion. Thank you all for being here. It takes the average woman an additional 91 days, 3 additional months to earn what her male peers earned in 2018, and that's unacceptable. From the North Carolina House to the U.S. House for 3 decades, I've been fighting to close gender and gender-based wage gaps. Today, I guess I feel a little bit like Fannie Lou Hamer, sick and tired of being sick and tired of the ongoing inequality. 56 years have passed since we signed the Equal Pay Act into law, and it's been 10 years since President Obama signed into law the Lilly Ledbetter Fair Pay Act. But today, in my district in North Carolina, women still only make about 82 cents for every dollar a man makes. And nationally, the statistic is even worse, 80 cents for every dollar. Women of color are even less likely to make as much as a man working the same job. Black women earn only 63 cents for every dollar a man makes. When women are shortchanged, our children, our families, our economy, all shortchanged. In fact, it shortchanges us about $500 billion a year. And that's why, as the new chair of the Subcommittee on Workforce Protections, I'm proud to host the subcommittee's first hearing on addressing persistent gender-based wage discrimination through the Paycheck Fairness Act. Because we can no longer wait while every day women across the nation are deprived of equal wages for equal work. Time's up for that. The Paycheck Fairness Act is an opportunity for Congress to strengthen the Equal Pay Act, bolster the rights of working women, and put an end to gender-based wage disparity once and for all. This is the right thing to do because it's right. It's always right to do what's right. And so at this time, I ask unanimous consent to introduce for the record 4 letters, all in support of the Paycheck Fairness Act, 1 from the National Partnership for Women and Families, 1 from the American Bar Association, 1 from the American Association of University Women, and the other from the National Women's Law Center. I look forward to our discussion today. Without objection, Madam Chair, I'm sorry. And I look forward to our discussion today and yield to Ranking Member Mr. Byrne for the purpose of making an opening statement.
Thank you, Madam Chairwoman. I now recognize the distinguished ranking member of the Workforce Protection Subcommittee, Mr. Byrne, for the purpose of making an opening statement.
Thank you, Madam Chairman. Women deserve equal pay for equal work. Congress affirmed this value with the Equal Pay Act of 1963, which made it illegal to pay different wages to employees of the opposite sex for equal work. Everyone in this room must continue to uphold and defend this important principle, but the legislation under discussion today, the so-called Paycheck Fairness Act, is the wrong approach to ensure that current equal pay protections are fortified. It may come as a surprise to some that the Paycheck Fairness Act offers no new protections against pay discrimination. Let me repeat that. The legislation under discussion today offers no new protections against pay discrimination. Instead, H.R. 7 imposes a one-size-fits-all mandate to one of the most varied and complex workforces in the world. Rather than allowing for informed discussions, the Paycheck Fairness Act strictly limits communication between employers and employees on key hiring decisions. Under this bill, the burdens laid on the backs of employers and the lack of clarity for employees are simply unworkable. The Paycheck Fairness Act is not designed to protect women. It is a false promise that creates opportunities and advantages for lawyers and not for working women. Instead of treating sex discrimination charges with the seriousness they deserve, the Paycheck Fairness Act will make it easier for lawyers to pursue lawsuits of questionable validity for the purpose of siphoning off unlimited paydays from settlements and jury awards, lining their own pockets and dragging women through tedious, never-ending legal dramas. Now, I know my fair share of lawyers, having previously practiced law myself. Many of them are great men and women working on behalf of their clients, but many of them are also all about the bottom line. And let me tell you, the Paycheck Fairness Act would be a cash cow for lawyers working on a contingency fee basis, some of whom get 40% or more of the award. The changes to the Equal Pay Act in H.R. 7 will also make it extraordinarily difficult, if not impossible, for employers to defend against pay discrimination suits, even when pay differences are the result of legitimate factors like experience, education, and performance. There remain bad actors in the world that engage in pay discrimination. It's repugnant and it's illegal, and those bad actors must be held accountable. But if we open the gates to limitless, frivolous lawsuits, we do a disservice to genuine victims seeking justice against offending employers. The best way we can create opportunities for all American workers, especially working women, is through strong economic policy. We know women are reaping the benefits of the present strong economy. More than half the jobs created in the last year have gone to women. Those women and the next generation of women in the workforce deserve more than empty promises and deceptively named bills. And I yield back.
Thank you, Mr. Byrne. Without objection, all other members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5 p.m. on February 26, 2019. I will now introduce the witnesses for our member panel.
Madam Chairwoman?
Yes,
I have a
Byrne.
parliamentary inquiry.
The gentleman from Alabama will state his parliamentary inquiry.
Madam Chairwoman, while I appreciate the purpose of this member panel and certainly the distinguished members on it, I'd like to point out that under the Democrat majority just last week at the Judiciary Committee, a colleague from our side of the aisle, Mr. Scalise, was denied the opportunity to testify before that committee despite having direct experience or perspective on the topic being discussed. So again, while I'm always willing to listen to my colleagues, I think it's a bit of a double standard by the majority to deny a member the right to testify when they disagree with that member, only to allow other members to testify when they happen to agree with them. Can the chairwoman explain why under the parliamentary customs of the House, members of the majority are being allowed to speak today, but members of the minority were not allowed to speak last week at the Judiciary Committee?
I cannot speak to what transpired in the Judiciary Committee. I can only speak to what transpired in the process of planning for this hearing. The majority and minority staff exchanged witness names on February 10th, 3 days ago. Minority staff never requested or even expressed interest in having a minority member testify. If they had, we would have granted that request. I will now move to introductions of the witnesses on our member panel. Representative Rosa DeLauro is the author of H.R. 7, the Paycheck Fairness Act. She represents Connecticut's 3rd Congressional District. She has long fought for America's working women and families. Representative DeLauro has led the effort in Congress to ensure equal pay for equal work. all employees access to paid sick days, and all workers access to paid family and medical leave. Representative Eleanor Holmes Norton is in her 15th term as the Congresswoman for the District of Columbia. Before her congressional service, President Jimmy Carter appointed her to serve as the first woman to chair the U.S. Equal Employment Opportunity Commission. In Congress, she has been a civil rights and feminist leader. Congressman Don Beyer is serving his 3rd term as the U.S. Representative from Virginia's 8th District. He was Lieutenant Governor for Virginia from 1990 to 1998 and was Ambassador to Switzerland and Liechtenstein under President Obama. Representative Beyer has spent 4 decades building his family business in Northern Virginia. Briefly, some instructions to our witnesses, which you probably already know. For the record, we appreciate all of the witnesses being here today and look forward to your testimony. Let me remind the witnesses that we have read your written statements. They will appear in full in the hearing record. Pursuant to Committee Rule 7D and committee practice, each of you is asked to limit your oral presentation to a 5-minute summary of your written statement. Before you begin your testimony, please remember to press the button on the microphone in front of you so it will turn on and we can hear you. As you begin to speak, the light in front of you will turn green. After 4 minutes, the light will turn yellow to signal you have 1 minute remaining. When the lights turn red, your 5 minutes have expired. I will first recognize Representative DeLauro.
Thank you very much, Madam Chair. I'm so pleased to be here this morning and to be with my colleagues, Congresswoman Eleanor Holmes Norton and Congressman Beyer. I want to say a thank you to Chairman Bobby Scott, as well as the Subcommittee Chair on Civil Rights and Human Services, Suzanne Bonamici, and Subcommittee Chair on Workforce Protection, Alma Adams. Let me recognize the ranking member of the full committee, Virginia Fox, as well as subcommittee ranking members James Comer, Bradley Byrne, and all of the members of the committee for welcoming us here this morning. I might just anecdotally tell you that it was some 12 years ago, in April of 2007, where Congresswoman Norton and myself testified before the Education and Labor Subcommittee on this topic of paycheck fairness. Also to tell you that we twice passed the Paycheck Fairness Bill in the House of Representatives in 2008 and 2009. And we are now here again, and we anticipate that we will be able to once again pass the Paycheck Fairness Bill in the House of Representatives. For more than 2 decades, we have pushed, we have battled to strengthen the Equal Pay Act of 1963. We launched side by side into the fray to elevate pay discrimination, to emphasize how central its impact as to working families. I cannot tell you how difficult it has been to break through on something so simple. Men and women in the same job deserve the same pay. Now the issue and the environment have collided. The House of Representatives just welcomed a diverse class in its history, the most diverse class, including the most female members ever. And equal pay is at the center of the discourse. The Paycheck Fairness Act would toughen remedies in the Equal Pay Act of 1963, giving America's working women the opportunity to fight against wage discrimination, receive the paycheck that they should have earned. Whether through Equal Pay Act or Title VII, current law makes it difficult for women to proceed with equal pay cases, even if a case proceeds and women are awarded a legal victory. The damages are often insubstantial, providing women with little compensation and employers with little deterrent from practicing future wage discrimination. Some claim the wage gap is a myth. Women continue to earn 20% less than men, on average, according to census data. Women of color, African American women, 61 cents. Latinas make only 53 cents on the dollar. When compared to white non-Hispanic men. We need to recognize the lack of pay equity translates into less income toward calculating pension, retirement, and in some cases, Social Security. The fact is that 60 years after President Eisenhower called for equal legislation and more than 55 years after President Kennedy signed the Equal Pay Act, pay discrimination is still very much a reality in our country. In 2017, there were 25,605 charges of unlawful sex-based pay discrimination with the U.S. Equal Opportunity Commission and 996 Equal Pay Act charges. Of course, by now we are all familiar with the case of Lilly Ledbetter and the Supreme Court decision that closed the courtroom door to all women. But we reopened that door with the Lilly Ledbetter Fair Pay Act, but the underlying issue of pay discrimination remains. It is systemic, it's discriminatory, it's a barrier, and just as our country has done to bring down other discriminatory barriers, we must use the collective power of the American people in the form of the U.S. Congress to ensure women have the power to gain economic security for themselves and their families. Under the Paycheck Fairness Act, any employee can sue for compensatory and punitive damages without facing the arbitrary caps they face under Title VII. It protects employees from retaliation from sharing salary information with coworkers, with some exceptions. It establishes a grant initiative to provide negotiation skills, training programs for girls and women. What it does not do, does not eliminate clear employer defenses against claims of discrimination. It makes clear that when an employer states that its pay scale is informed by, quote, a factor other than sex, it must actually be true, not just an excuse to continue discriminatory practices. H.R. 7 merely restores Congress's intent, which has been undermined by court interpretations over the years, allowing employers to escape liability in cases in which their decisions were in fact based on sex. I thank the committee for this opportunity to testify and for addressing this critical issue. When President Kennedy signed the Equal Pay Act over 55 years ago, he said, and let me quote, "Add to our laws another structure basic to democracy and affirm our determination that when women enter the labor force, they will find equality in their pay envelope." We have the opportunity to make good on that promise that presidents of both parties have made. Let us seize that opportunity. I thank the chair and I thank the committee for allowing me to speak this morning.
Thank you very much, Representative DeLauro. I now recognize Representative Eleanor Holmes Norton.
Thank you, Chairwoman Bonamici, Chairwoman Adams, Ranking Member Comer, Ranking Member Byrne. I appreciate the opportunity to testify on H.R. 7. I'll try to summarize my testimony. I especially welcome H.R. 7 as it bears on my own work when I chaired the EOC and moved the jurisdiction of the Equal Pay Act under reorganization under President Carter from the Labor Department to the EOC so that like statutes could be more easily enforced under the same agency. The Equal Pay Act was the first of the great Civil Rights Act, so we are way overdue in bringing it up to date and strengthening it as the DeLauro bill does. This bill makes it easier for complainants to participate in a class challenging pay discrimination. Now, pay discrimination class members should, once a complainant files, should include all who probably make the same or relatively the same amounts of money. That would be a more efficient way to enforce the Equal Pay Act. I appreciate that it improves Labor Department's ability to enforce the EPA through the Office of Federal Contract Compliance. I particularly appreciate that my good friend, the champion of this bill, Representative DeLauro, has included My Pay Equity Act for All in H.R. 7. This act does something that I think most of us may not even recognize to be discrimination. Some of us may do it ourselves. That is to ask an applicant for his or her employment history. Even though many employers may not intend to discriminate, the effect almost surely is to discriminate when you consider where women are and often people of color are in the workplace. Evidence shows that the historically disadvantaged groups often start out with unfair and artificially low wages compared with their white male counterparts. Imagine how this discrimination then is compounded from job to job, since you can't build on the salary you should have made because you didn't make the salary you were entitled to in the first place. Job offers should be based on an applicant's skill, merit, not on salary history. This bill, my own bill, would allow the assessment of penalties against employers who ask salary and act on salary as a way of considering salary and hiring. We know what is true because of the verified studies. To cite one, a recent study showed that when employers were not allowed to ask the salary history, the employee earned 9% more than when the employer was allowed to ask that history. I believe this is one of the major reasons for the stubborn gap that we have not been able to move much between the wages of men and women. The H.R. 7 would also direct the EOC to collect data on salaries based on a number of criteria, including sex. What? We didn't know until now what the difference was based on sex because we didn't have the data. Everything I did at EOC depended on the data. Most often with class actions, where having the data, you can bring actions that involve large numbers of people once there is a remedy. The fact that we have not had the relevant data on sex may be one reason why women and minorities have made more progress in getting jobs than in equal pay once they have those jobs. I very much appreciate the priority, Madam Chair, that you have given to this long overdue bill.
Thank you very much for your testimony, Representative. I now recognize Representative Don Beyer from Virginia.
Thank you, Chairman Bonamici, Chairman Adams, Ranking Member Comer, Ranking Member Byrne. Thank you very much for inviting me to participate in this important discussion on equal pay for equal work. We know when women succeed, America succeeds. Women are running in unprecedented numbers, they're marching in unprecedented numbers, and they're winning in unprecedented numbers with, I think, 131 women now in Congress. And I'm incredibly grateful to play a supportive role in this effort that Rosa DeLauro and Eleanor Holmes Norton have been pursuing for decades. My priority is women's empowerment and the elevation of women's voices and concerns. We've made progress, the Lilly Ledbetter Fair Pay Act, the Survivors' Bill of Rights Act, but there's still much more to do because persistent pay gaps exist in the U.S. workforce that correlate specifically with sex, race, and ethnicity. Unequal pay for unequal work, for equal work, exists over a spectrum of jobs, regardless of education level, regardless of geographic location. Economists have found that 62% of the wage gap can be explained by three factors: experience, industry, and occupation, but the remaining 38% cannot be explained by such differences. And while federal law specifically prohibits compensating men and women differently for the same work, the law must be strengthened. Effective enrollment of this mandate is impeded by a lack of sufficiently robust and reliable data on compensation, including data by sex and race. Just this weekend, we spent time with our middle daughter, who is a senior front-end web designer manager. She likes to emphasize that last word. And so she's a woman who codes. And she had just discovered to her dismay that her male counterparts were making more money for doing exactly the same job. It's this lack of data that acts as a barrier to closing the persistent pay gap for women and people of color. As a business owner and employer, I understand the value of data because the aphorism is you can't manage what you don't measure. We like to think we're driven by data. Data exposes trends in hiring, paying, and promoting employees, which can inform the appropriate interventions. Data can reveal sex and racially segregated jobs, or a lack of women or people of color in upper management, and disparate salaries, benefits, or bonuses. Literally, it can arm businesses with the information that they need to remedy unjustified pay gaps. It can wake many of us up who are leading businesses to understand what's happening within our own workforce. And it can provide a lens to examine the intersectionality of issues that can contribute to wage gaps. Since the enactment of the Civil Rights Act in 1964, the EEOC has been empowered to collect employment data to identify these discriminatory employment patterns based on race, gender, and national origin. And for over 50 years, companies use the EEO-1 form to report this important demographic data. So as we look to ensure true paycheck fairness, it's only natural that we ask the EEOC to improve upon its system of data collection and help with wage data to identify wage disparities. Only then will businesses have the tools to better identify, correct, and eliminate illegal wage disparities. In business, we're constantly thinking about how we can innovate, provide a better product, create an ever better culture. Guaranteeing that men and women receive equal pay for equal work is a principle rooted in our nation's commitment to equality and fairness. The Paycheck Fairness Act has been introduced in every Congress since the 105th. The time has come to pass this legislation. Today is an important day for us to move forward together, for us to make that difference we all know is needed, for us to break through for change. Thank you, Madam Chair. I yield back.
Thank you very much, Congresswoman DeLauro, Congresswoman Holmes Norton, and Congressman Byer. As we transition to the next panel, which we will do immediately, I want to remind my colleagues that pursuant to committee practice, materials for submission for the hearing record must be submitted to the committee clerk within 14 days following the last day of the hearing, preferably in Microsoft Word format. The materials submitted must address the subject matter of the hearing. Only a member of the committee or an invited witness may submit materials for inclusion in the hearing record. Documents are limited to 50 pages each. Documents longer than 50 pages will be incorporated into the record via an internet link that you must provide to the committee clerk within the required time frame. Please recognize that years from now, the link may no longer work. Again, I want to thank the witnesses for their participation today. What we have learned is very valuable. We will now seat the second panel. Thank you for joining us. I will now introduce our witnesses for the second panel. Ms. Fatima Goss-Graves is the President and CEO of the National Women's Law Center. Ms. Goss-Graves has served in numerous roles at the National Women's Law Center for more than a decade and has a distinguished track record of working across a broad set of issues central to women's lives, including income security, health and reproductive rights, education, access, and workplace justice. Ms. Camille Olson is a partner at the law firm Seyfarth Shaw LLP. Since 2013, Ms. Olson has served as chairperson of the United States Chamber of Commerce's Equal Employment Opportunity, EEO, subcommittee. She has represented companies nationwide in all areas of litigation. I'm pleased to recognize my colleague, Ms. Pramila Jayapal, to briefly introduce Ms. Kristen Rowe Finkbeiner.
Thank you so much, Madam Chair, for this opportunity. It is my great honor to introduce Kristen Rowe Finkbeiner, who is the Executive Director and CEO and the co-founder of Moms Rising, who is joining us from my home state of Washington. We're so proud of the work that Moms Rising has done, not just in Washington state, but around the country. Kristen has been deeply involved in grassroots engagement and policy analysis for more than 2 decades, and Moms Rising now has over 1 million members and works to increase family economic security, to decrease discrimination against women and mothers, and to build a nation where businesses and families can thrive. Thank you so much for joining us, and you continue to make us proud in Washington.
Thank you, Rep. Jayapal. Now I want to introduce Ms. Jenny Yang. She served as the chair of the U.S. Equal Employment Opportunity Commission, or EEOC, from 2014 to 2017, and as a member of the commission from 2013 to 2018. She is currently a partner with Working Ideal, which advises employers on building inclusive workplaces, recruiting diverse talent, and ensuring fair pay. She's also a fellow at the Urban Institute, where she examines the impact of changing workplace structures on low-wage workers. Prior to her time at the Commission, she spent 15 years litigating equal pay and other discrimination cases on behalf of employees. We appreciate all the witnesses for being here today. We look forward to your testimony. Let me remind the witnesses that we have read your written statements and they will appear in full in the hearing record. Pursuant to Committee Rule 7D and committee practice, each of you is asked to limit your oral presentation to a 5-minute summary of your written statement. Let me remind the witnesses that pursuant to Title 18 of the U.S. Code, Section 1001, it is illegal to knowingly and willfully falsify any statement, representation, writing, document, or material fact presented to Congress, or otherwise conceal or cover up a material fact. Before you begin your testimony, please remember to press the button on the microphone in front of you so it can turn on and all members can hear you. And as you begin to speak, the light in front of you will turn green. After 4 minutes, the light will turn yellow to signal that you have 1 minute remaining. When the light turns red, your 5 minutes have expired, and we ask that you wrap up. We will let the entire panel make their presentations before we move to member questions. When answering a question, also please remember to turn on your microphone. I will first recognize Ms. Gosgraves for your testimony.
Thank you, Chair Bonamici, Chair Adams, Ranking Member Cormer, Ranking Member Byrne, Chair Scott, and Ranking Member Fox, and all the members of the committee. Thank you for the opportunity to submit testimony today. I'm Fatima Gosgraves, President and CEO of the National Women's Law Center. It's been a decade since Congress passed the Lilly-led Better Fair Pay Act, and in that time, the push for equal pay across this country has only increased. And Congress, unfortunately, has failed to keep up. States and cities have responded accordingly by attempting to fill the gaps in federal law. Since 2016, 6 states have prohibited employers from relying on prior salary history information from job candidates in order to set their new salaries. 3 have tightened legal loopholes that allow employers to justify paying women less for equal work. And because pay discrimination is so often cloaked in secrecy and seldom obvious to the person who is actually directly affected, states and localities across this country have taken measures in recent years to bring pay practices into the light through pay data reporting requirements and laws protecting employers' rights to talk about how much they make with each other. In fact, 18 states in the District of Columbia have enacted provisions to stop employers from retaliating against employees who discuss their own pay with each other. Corporate leaders have also recognized that equal pay just makes business sense. More than 100 major companies took the White House Equal Pay Pledge, and companies from Accenture to Gap to Raytheon and many more have followed through by instituting measures to identify and close pay gaps. And the push for equal pay doesn't stop at the U.S. borders, with United Kingdom being one of the companies that has recently found that public and private employers in the UK, it's 250 employees or more, are now required to annually publish the difference between the average pay of their male and their female employees. This new requirement has already prompted companies to outline action plans for how they're going to reduce and address their pay gaps. But in the face of this giant cultural shift that has added new urgency to calls for equal pay around this country, Congress still has failed to act. And it's not enough for some states to pass laws or for some employers to do the right thing or for global corporations to feel indirect pressure because of laws in other countries are stronger. Every woman in this country, especially the Black women and Latinas and Native women who experience the most yawning pay gaps, deserves robust baseline equal pay protections in the federal law that actually work. So we're talking about a gender wage gap that has not dramatically changed over the last decade and that follows women into retirement. It's a gap that means Latinas lose over the course of a 40-year career over $1 million compared to white non-Hispanic men. That's really life-changing money. And it's the sort of money that has the potential to transform opportunities for individuals and for families and for communities. So you'll hear from some skeptics that the wage gap is just about women's choices or that it's impossible to actually abandon practices that have meant again and again that women make less over time, or that more than 50 years after the Equal Pay Act was passed, there's no need to update our kind of ineffective laws. But I just believe we can do better. It's time to match the seriousness of the women in this country who are calling for change. The Paycheck Fairness Act is a part of a response to this urgent call to shift the ways of doing business that have persistently devalued women's work. The bill promotes pay transparency by barring retaliation against workers who voluntarily discuss or disclose their own wages and requires employers to report pay data to the EEOC. It prohibits employers from relying on salary history to set pay when hiring new employees so that pay discrimination doesn't follow women and people of color from job to job. And employers are paying based on the job, not based on the fact that women and people of color tend to generally make less. And it closes loopholes that have allowed employers to pay women less than men for the same work without a legitimate business justification related to the job. And it ensures women can receive the same robust remedies for sex-based pay discrimination that are currently available to those who are subjected to race and ethnicity discrimination under other laws. So by updating our equal pay laws to reflect our reality today, the Equal Pay Act could be the sort of statute that would really advance equity and dignity for women at work. So thank you for the opportunity to testify today. As you said, my full testimony will be submitted for the record, and I look forward to any questions.
Thank you for your testimony. I now recognize Ms. Olson for your testimony.
Good morning, subcommittee members. As an employment attorney at Seyfarth Shaw, I work with companies nationwide, analyzing compensation practices to ensure that pay differences between employees performing equal work are job-related. I have also litigated nationwide numerous cases analyzing and alleging violations of Title VII, the Equal Pay Act, and state equal pay laws. My written testimony describes opportunities to strengthen the Equal Pay Act. It also details a number of significant concerns that I have with H.R. 7. I'd like to share 3 of those opportunities and those concerns with you today. H.R. 7 presumes that the reported wage gap and all employee current pay rates result from employer discrimination and rewrites existing legal requirements, remedies, and class action procedures contained in the Equal Pay Act. Specifically, H.R. 7 effectively eliminates the factor other than sex defense, prohibits an employer from seeking or relying on an applicant's current pay when extending a job offer, and imposes unlimited compensatory and punitive damages while inserting a more attorney-friendly class action device, among other amendments described in my written testimony. First, H.R. 7 de facto eliminates the factor other than sex defense. Under the Equal Pay Act, most courts currently require the employer prove that any pay difference is job-related. If the employer cannot do so, the plaintiff prevails. A plaintiff is not required to make any showing of discriminatory intent under the Equal Pay Act. Under H.R. 7, an employer would be required to prove, with respect to every pay differential between employees, not only that the reason was job-related, but also that it paid one employee more because it was a business necessity, that the business necessity necessarily covered 100% of the pay difference, and that the business necessity was not derived by a sex-based differential in compensation. And even if an employer does that, it still loses if years later a plaintiff's attorney identifies an alternative employment practice that would have served the same purpose without a wage difference. But what if the alternative offered in litigation is less efficient, more costly, or an unproven alternative on a time-sensitive project that needed immediate staffing? Is the employer's proven business necessity now rejected? Under H.R. 7, the answer is yes. Similarly, H.R. 7 requires employers to ignore an employee's competitive job offer unless it can prove that the higher competitive wage offer is not the result of historical wage discrimination by the other employer. This is an impossible burden, and it would require the employer to prove the other employer's wage rate was not set discriminatorily. Second, under H.R. 7, employers must ignore an applicant's current pay when making an offer. If it doesn't, it's a per se violation of federal law. Few applicants leave their current job for a lesser paying job, and current pay provides valuable information regarding a candidate's actual experience, performance, or expertise. The EEOC's compensation manual describes justifiable reasons for considering an applicant's prior salary. H.R. 7 keeps both sides in the dark about the expectations that each party has regarding pay at the job at issue. Third, H.R. 7's expansion of available damages and class action under the Equal Pay Act is unwarranted. H.R.'s unlimited compensatory and punitive damages far exceed remedies available under Title VII and are in addition to the significant penalties that already exist. In addition, the changes to the class action methodology would significantly expand the class size because employees would be required to opt out of the class as opposed to opt in. Despite these stated concerns, there are opportunities to improve the Equal Pay Act. For example, adding language that expressly states that pay differences between workers performing the same work must be based on job-related measures, providing employees with an express protection within the Equal Pay Act against retaliation, and finally, providing employers with incentives to engage in voluntary, self-critical compensation analyses that encourage self-evaluation to eliminate any unjustified pay discrepancies without the need for litigation. In summary, H.R. 7 is based on false premises and is unworkable as a practical and legal matter. Subcommittee members, thank you for the opportunity to share some of these concerns and opportunities with you today.
Thank you for your testimony. I next recognize Ms. Rowe Finkbeiner for your testimony.
Thank you, Chairs Bonamici and Adams, and thank you.
Please press your microphone button.
Thank you to Chairs Bonamici and Adams, and thank you also to Ranking Members Comer and Byrne for the opportunity to speak today. At Moms Rising, an organization with over 1 million members, including members in every state in the nation, we regularly hear from women who are experiencing unfair pay, who fear retaliation in workplaces and therefore cannot speak up, and who need the protections the Paycheck Fairness Act would provide, including freedom from retaliation, making it easier to come together to collectively challenge pay discrimination, an end to the use of prior salary histories to set current salaries, and the additional protections provided that would move us closer to pay parity. Stories like this one from Laura. Laura and her husband met at Columbia University and graduated with the same degree. They both got jobs at the same agency in the exact same position. However, she was paid $5,000 less than he was. When Laura asked the agency about the discrepancy, she was told to accept the pay or they would give the job to someone else. Laura is not alone. More women are graduating from college than men right now. But after only 1 year in the labor force, women are making less money. Unfair pay and the fear of losing wages you depend on in retaliation for speaking out is much too common. That's why not only directly prohibiting retaliation, but also making it easier to come together to collectively challenge pay discrimination is vitally important. Let me tell you too about Felicia. Felicia experienced blatant wage discrimination while working at a technical support center for a large retail corporation. Felicia was hired to work the exact same job as her brother-in-law and discovered she was being paid about $4 less an hour to do the same work. She went on to find out that all the male employees were also making more in the same job, and as it turned out, the women were making less. Felicia's not alone either. And her experience demonstrates why preventing retaliation against employees who discuss their wages with other employees is critical, as well as why prior earning history should never be used to set current earning rates, because that compounds unfair pay over time, takes money out of women's pockets and out of our economy, and significantly increases poverty. But this isn't just about Laura or Felicia. This is about the women of America, our families, our economy, and our children's future. It is time. Our country has changed, but our public policies haven't kept up. Women became half of the paid labor force for the first time in the last decade. 3/4 of moms are now in the labor force, more than half of whom are the primary breadwinner. Yet women are experiencing unfair pay every day, with moms and women of color experiencing the highest levels of wage and hiring discrimination. Keep in mind that a full 81% of women become mothers, which means this double wage hit, and sometimes triple wage hit if you're a mother of color, is impacting the vast majority of women in our nation. Take Valerie, a mom who discovered her male coworker who was hired on the same day with the same title was being paid substantially more, even though she had more duties and responsibilities. Valerie went to the owner to request equal pay. She was told because her coworker was married and male, he needed a higher income. Valerie pointed out that since he was married and had a wife also working outside the home, he actually had 2 incomes, while she only had 1. Her boss was cordial but adamant. She had no choice but to live with it. The sad truth is that right now, Dads are getting wage boosts, and moms are getting pay cuts. The other sad truth is that being a mom is now a greater predictor of wage and hiring discrimination than being a woman. Our country, which claims to love, adore, and respect motherhood, pays women with children just 71 cents to every dollar it pays dads. And moms of color, as well as single moms and moms in low-wage work, experience increased wage hits on top of that. Subconscious, negative assumptions are hurting women, children, businesses, and our economy. This is an urgent matter. Wage, hiring, and advancement discrimination is happening every day, despite numerous studies showing businesses tend to make higher profits with women in leadership and that better decisions are made with diverse decision makers. For instance, a study of all Fortune 500 companies found higher levels of women in leadership correlated with higher profits. It's time to stop treating women unfairly in the United States of America. It's time for women to be able to join together, to be able to share information, and to demand that current pay not be set by past pay without fear of retaliation. It's time to pass the Paycheck Fairness Act. Thank you.
Thank you for your testimony. I now recognize Ms. Yang for your testimony.
Members of the committee, thank you for the opportunity to testify today. For over 50 years, pay discrimination has been illegal, but our existing laws have not lived up to their promise. The Paycheck Fairness Act provides a balanced, workable, and much-needed approach to better combat pay discrimination. While my testimony today is informed by my experience at the EEOC and litigating cases on behalf of workers, it is also informed by my experience at Working Ideal, where we advise employers on building inclusive workplaces, recruiting diverse talent, and ensuring fair pay. And while I'm a fellow at the Urban Institute examining the changing workplace, my views here today are my own and should not be attributed to these organizations, their boards, or funders. To illustrate some of the challenges workers face under existing law, I'd like to share one case that has stuck with me from my time at the EEOC. Margaret Thibodeau Woody was an adjunct professor who Houston Community College hired for one of two open faculty positions. The man hired for the second position had the same degree from the same university and similar work experience. Initially, the college offered them both the same starting salary. When Margaret tried to negotiate, she was told she could not. Yet the male candidate was permitted to negotiate a salary $10,000 higher. When Margaret learned of this and approached Human Resources, she was told nothing could be done. Indeed, her supervisor urged her to rely on her husband's salary for additional income. In addition, Margaret alleged she faced retaliation, receiving a lower performance evaluation and unfair discipline. The district court dismissed her case, and the EEOC filed a friend of the court brief in support of her appeal. Although the Fifth Circuit rejected Margaret's retaliation claim, it reinstated her pay claim. This was 6 years after she began work at the college. Unfortunately, experiences like Margaret's are all too common. Her fight for equal pay highlights 3 broad themes that underscore the need for the Paycheck Fairness Act. First, the lack of clarity in existing law has created unjustifiable barriers for workers. Second, a culture of pay secrecy hides the problem. And third, employers need greater incentives to evaluate their pay practices. First, courts have interpreted the Equal Pay Act in ways that have made it extraordinarily difficult for employees. The EPA provides employers with a defense where disparities are based on a factor other than sex. This has become an expansive catch-all under which some courts have allowed employers to rely on arbitrary and often discriminatory considerations. The Paycheck Fairness Act would make clear that an employer must rely on a reason that actually relates to the job as a business necessity. In addition, the Act would prohibit employers from relying on prior salary to set pay. As we saw with Margaret's experience, if a new employer were to rely on her prior college salary, which was $10,000 less than a man performing the same job, that new employer would carry forward past discrimination. The Paycheck Fairness Act also takes an important step to clarify when workers can compare jobs within any establishment. Some courts have interpreted this provision of the Equal Pay Act in a manner that is out of step with the realities of today's workplace by limiting comparisons to a single brick-and-mortar facility. The Paycheck Fairness Act ensures that employees can challenge discrimination that extends to at least the county or similar subdivision when they perform equal work at different locations. Second, a culture of secrecy has surrounded pay, which has kept employees from learning about pay disparities. The Act addresses this in two ways. Although existing law provides limited protections for workers who discuss pay, the Paycheck Fairness Act would provide a coherent set of rules to protect employees from retaliation. The Act also directs EEOC to collect pay from employers. During my tenure as chair, the agency moved forward to collect summary pay data, a vital tool to better identify discrimination and strengthen enforcement. The current administration abruptly halted this data collection. Reporting pay data provides a catalyst for employers to review their pay practices and make necessary corrections. Finally, the Paycheck Fairness Act provides much-needed incentives for compliance. In closing, to ensure that the promise of equal pay becomes a reality, our laws must change. Thank you.
Thank you for your testimony. Now we're going to move to member questions, and under Committee Rule 8A, we will be under the 5-minute rule. As chair, I will go first, followed by the ranking member of the Civil Rights and Human Services Committee, Mr. Comer, then the chair of the Workforce Protections Committee, Ms. Adams, and the ranking member of the Workforce Protection Subcommittee, Mr. Byrne, and then the chair of the full committee, Mr. Scott. Then we will move to members. I now recognize myself for 5 minutes for the purpose of questioning the witnesses. Ms. Goss-Graves, in your testimony, you discussed data that demonstrates pay discrimination is a significant cause of the gender wage gap for women, especially women of color, and you mentioned that women with caregiving responsibilities face persistent discrimination in the workplace, resulting in lower wages. Yet pay discrimination remains difficult to detect. Provisions in the Paycheck Fairness Act would require the EEOC and the Department of Labor to collect information from employers on compensation disaggregated by sex, race, and nationality. How would these provisions help detect discrimination, and how would detecting this discrimination affect the lives of working families?
So we basically have two problems. One is a transparency problem because workers who are experiencing pay discrimination very rarely know that that is the case. And we also don't have the right incentives in place. And so the idea is if an employer is collecting and then reporting that data to the EEOC, the first thing it's going to do is going to look to make sure that if there are problems, it's going to address it. It is unlikely that it is going to hand over to the EEOC data that reflects that the ongoing case of discrimination. So it gives them a chance and an opportunity to do the right thing first, but it also gives the EEOC the opportunity to have more effective enforcement, which is especially important because of the high rates of retaliation that come to people who try to exercise their rights, whether it is around pay discrimination or any other form of discrimination.
Thank you. Ms. Yang, in your testimony, you discussed the reporting burden on workers facing pay discrimination, which combined with the lack of sufficient remedies leads to underreporting. You also mentioned when you work at the EEOC, you worked on updating the guidance on retaliation. In what ways are the Equal Pay Act, Title VII of the Civil Rights Act, and the National Labor Relations Act insufficient to provide workers with the rights and tools they need? And how would the Paycheck Fairness Act help address systemic pay discrimination and provide relief to workers affected?
Thank you for that question. Currently, under federal law, there is limited protections for employees who discuss pay. Under the Title VII anti-retaliation prohibition, that discussion needs to be considered protected activity, opposing or participating in an investigation. The Paycheck Fairness Act provides one consistent and coherent standard that everyone can understand. So workers will not be afraid to share information that is vitally needed to identify pay discrimination.
Thank you. And this is a question for both Ms. Goss-Graves and Ms. Yang. In her testimony, Ms. Olson cites a district court decision in the Chamber of Commerce for Greater Philadelphia versus City of Philadelphia case as evidence that prohibiting employers from asking workers about salary history is an unconstitutional impairment of free speech. Ms. Cosgraves and Ms. Yang, do you know the status of this case? And in your opinion, after having worked in this field for a long time, was the case correctly decided? And does the prohibition on asking about salary history prior to an offer of employment in the Paycheck Fairness Act raise constitutional concerns?
I don't think that the Paycheck Fairness Act raises constitutional concerns. First, that district court decision itself said that relying on salary history, having a provision that says you can't rely on salary history itself doesn't raise constitutional concerns. I have to say that case is right now on appeal. I think the district court got the second part of it wrong, where they said it did raise constitutional concerns to prohibit people from asking about salary information. This is sort of a common thing in federal law where the underlying provision, say the ADA, where the underlying provision is that you can't discriminate based on disability. You also can't go around asking people if you are disabled. And the reason is so that people can, when they are making those employment decisions, be really clear that they're not actually backdoor violating the law as well.
Ms. Yang, do you agree with that analysis?
I agree with that, and it is quite common under many of our federal laws to have prohibitions for asking about certain information, such as our Disability and Genetic Non-Discrimination Acts, which explicitly prohibit certain pre-employment inquiries.
Terrific. And I did want to follow up on the rest of my question to Ms. Cosgraves about how the Paycheck Fairness Act would affect especially families. I'm about to run out of time, so I'm going to ask you, I know some of it is in your written testimony, to perhaps follow up on that at another opportunity. I would like to request unanimous consent to enter into the record a letter from a coalition of many stakeholders highlighting the importance of passing the Paycheck Fairness Act to address pay discrimination. And because I want to be a good role model and stick to my time, I'm going to yield back and recognize Ranking Member Comer for 5 minutes for the purpose of questioning the witnesses.
Thank you, Madam Chairman. Ms. Olson, thank you for your testimony. As you have noted, private sector businesses do not have rigid pay scales like the federal government has for civil servants. And most businesses today do not have hundreds of jobs that are exactly the same as a factory may have had 100 years ago or even 50 years ago. Based on your experience advising businesses on compensation issues, would the provisions relating to business necessity in H.R. 7 be workable and effective in today's vibrant and changing economy? And can you provide examples to support your view?
Please turn on your microphone.
Thank you very much for your question. The concept of business necessity as applied in H.R. 7 is unworkable, and it is an impossibly high standard to meet. It says basically that a job-related or business-related factor has to be judged against, if you didn't do it, what? There's no specific definition here, but what? If you didn't do that, if you didn't pay the worker more, would the business continue without the employee being hired, or without the employee being retained? The fact that there are so many different variables that are job-related and support differences in qualifications, in experience, in production, in contributions, and also in the ability to retain employees who may get competitive offers from others, requires employers to be able to respond to those, to motivate, to retain, to reward employees, and to do so with respect to factors that are job-related, which is what the majority of courts say, and what the statute really requires, based on the statutory construction of the way it's drafted, is a standard that is workable and does not allow pay discrimination to be inserted. But instead, if an employer is required to say, I've got to prove it's a business necessity, not just related to the job, how do I do that? And even if I do that, I've got to explain that that business necessity covers 100% of any difference. And if in litigation later, a plaintiff's lawyer said, well, did you consider this particular example of another way that you could have done it? For example, raising the pay of all employees, if that was financially feasible. Is that an example that an employer then would have to face a jury with in connection with that issue? What will it really leave employers doing? Really not making distinctions. Employees lose. Employees with different, with better, with higher qualifications that relate to the job they're performing aren't going to be rewarded for those things.
Ms. Olson, I noted H.R. 7's mandate that businesses provide employee pay data to the EEOC. Among other concerns, I have little confidence in the federal government's ability to keep this data confidential, and I worry that workers' privacy would be breached. Do you share these concerns? Can you also comment on how large a burden it would be for employers to submit hiring, termination, and promotion data in addition to pay data, all disaggregated by sex, race, and national origin? Is this provision necessary and practical, or do the bill sponsors have other motivations in mind?
I can't really speak to the motivations on these particular issues, but what I can speak to is what burden it would be and the lack of the benefit and the concerns I have with respect to the confidentiality. With respect to the issue of burden, employers don't collect today. There's no federal law or record-keeping requirement that they collect information regarding the national origin of employees. So this is an entirely new obligation based in a law related to sex discrimination, and I didn't see any directives that relate to the issues of including national origin and race related to this issue. In addition, employers don't collect in a digitized or well-documented way necessarily the promotions in their systems that relate to pay differences. So that would be a complete review and trying to reorder and restructure the way their own record keeping is done. And unless an employer is a federal contractor, they're not required to keep information regarding terminations. So those are all new record keeping requirements that at this point have no limits in H.R. 7, and there are no descriptions of the privacy or confidentiality protections that would be applied. And let me just mention, H.R. 7 describes generally that the data collected will be disaggregated data. Does that mean by employee? Or does that mean by group? We don't know from H.R. 7, and I would just tell you that the privacy and confidentiality concerns, if in fact it is by employee, are even more significant.
Thank you. Madam Chair, I yield back.
Thank you. I now recognize Chairwoman Adams, the Chair of the Workforce Protection Subcommittee, for 5 minutes for the purpose of questioning the witnesses.
Thank you, Chairwoman Bonamici, and thank you all for your testimony. Ms. Yang, in your testimony, you stated that reliance on salary history in setting starting pay also runs the risk of perpetuating past discrimination that occurred in previous jobs. Can you expound on this a little bit?
Yes, thank you. That's a very important question, Congresswoman. The problem that we've seen is that historically, where employers rely on past salary, they can be carrying forward past discrimination, as in the situation of Margaret's that I shared with you before. It can be, in fact, both discriminatory as well as arbitrary what prior employers may pay individuals. For example, if in a particular field, women tend to work in the public interest, social sector, and they're moving into the private sector, women would be at a lower salary in a previous job. In fact, they may have had more experience because they had a lower budget and were actually doing more. But in moving to that new private sector job, a man coming from private sector may be paid more even though they are performing the same work of an equal skill and responsibility. So that's what this Paycheck Fairness Act provision really is intended to root out.
Thank you. Ms. Olson agreed with the district court's decision in the Philadelphia case that banning an employer from asking about salary history is unconstitutional. However, Ms. Olson disagrees with the court's decision that employers should be prohibited from relying on pay history when determining pay. Once asked, how can one be sure that an employer isn't relying on salary history when determining salary? Shane?
Well, the employer, with the Paycheck Fairness Act, the employer would not be permitted to ask for that information or utilize that information. And there are many more ways for employers to set starting pay that is actually based on the work being performed, and that is the ultimate goal of the Equal Pay Act and the Paycheck Fairness Act. And that, the starting salary is where we see the most significant disparities that get perpetuated through time. So that is a very important part to make sure employers are really carefully checking assumptions, stereotypes that may be in their process, and ensuring that it's truly job-related.
Thank you. Ms. Gross-Graves, the Paycheck Fairness Act clarifies that if an employer justifies pay disparity based on a factor other than sex, such defense must be based on a bona fide job-related factor such as education, training, or experience that's consistent with business necessity. Can you give us examples of how this business defense has historically been applied in ways that perpetuate gender-based wage discrimination?
So what has happened in some of the cases is that some courts have allowed employers to have vague references to the market or to point to the fact that the guy was a better negotiator, so that's why, or perceived as a better negotiator, so that's why they paid them more, or relying on the fact that the woman made less in the past to sort of salary match, to match that past salary, and saying that's why we're paying them more. You know, those sorts of justifications, or any old reason as long as they're not saying sex, you know, so it's become this giant loophole in the law. And so what the Paycheck Fairness Act would really do is ask two different questions. So, you know, one, is the reason that you're offering actually related to the job? Are you pointing to something to pay them more that actually is not related to the job? And then second, is it something that you actually need to do? Or is there some alternative that would work better? So perhaps you had been salary matching and as your way, because that was your way of assessing the market. But there's lots of ways to assess the market. There are standardized things that give you information about assessing the market. There's Glassdoor, there's PayScale. There's a lot more than salary matching to assess your market. So it really requires an employer to think hard about, am I paying someone fairly, and am I paying them for the job that I'm asking them to do? So you actually make the Equal Pay Act's promise of equal pay a reality.
Yeah, Ms. Olson suggests that employers should be given incentives like the elimination of liquidated damages for conducting self-audits to address pay inequities. Why is this insufficient in your thinking?
You know, we're more than 50 years after Congress said we should start paying people equally for the same work. So, you know, the idea that we need incentives to comply with a law that's 5 decades old is a little bit troubling when people have been harmed along the way in all these many decades.
Thank you very much, Madam Chair. I'm going to yield back. I'm out of time.
Thank you very much, Congresswoman Adams. And I now recognize the ranking member of the Workforce Protection Subcommittee, Mr. Byrne, for 5 minutes for questioning the witnesses.
Thank you, Madam Chairman. Ms. Olson, I really appreciate your being here today. You're recognized among the labor and employment bar in the United States of America as one of our leaders. You've been practicing in this area since 1983. You're one of the first women to practice in this area. So you bring a wealth of experience spanning many years, and I appreciate your vantage point on it. You know, we all want to see equal pay for equal work, but as federal policymakers up here in Congress, our question is, what's the best way to achieve that? So we have this proposed bill, H.R. 7, in front of us, which I know you're familiar with, and I want you to use your experience, many years of experience in equal pay cases, and discuss whether the new remedies and the new class action provisions in that bill will actually achieve the outcome we all want to achieve. And I also want you to address, if you will, your own experience in this area and what you think it will do to both employers and employees. Press the button.
Thank you very much. First of all, let me talk about the current Equal Pay Act. Even with reference to the cases that were described today by other witnesses, you heard them describe those cases worked. The cases continued. They were sent back. The law today does not say an employer can just articulate a reason, any reason, a reason they don't consistently apply, a reason that's really not related to a job. The employer has the burden of proof under the Equal Pay Act. It's different than Title VII. It's much harder in that sense. And the burden of proof is to demonstrate a consistent, bona fide, job-related factor is being used. And in cases that are cited in my testimony and some that were cited today by others, the courts looked at that proof and said, it's not enough to just articulate something that you're not consistently applying. That's not bona fide. And it's not enough if it's not directly related to the job. You've got to show a nexus that matters. In terms of the issues of what's currently available to an employee who files a claim under the Equal Pay Act, you've got back pay, injunctive relief in terms of front pay, double damages in terms of the back pay, attorney's fees, costs, interest, a much longer statute of limitations. Limitations in Title VII is 300 days. Under the Equal Pay Act, it goes back 3 years if there's a willful violation. So the employer who may have not been found to have ever discriminated on the basis of someone's sex, but just can't explain the entire difference in terms of the differences in pay, could be held to unlimited punitive and compensatory damages. That's a windfall for plaintiffs' lawyers and will not allow, I know from my experience in litigating these cases to be resolved because of the endless, limitless potential for damages, as opposed to the realities of what you're looking at. So that's one point. And then on the issue of class actions, and I litigate class actions around the country, the class action mechanism that currently exists here is the same one that exists for wage and hour laws in our country, the same one that exists for the age discrimination claims that are brought. And it's one that, in my experience, moves much faster for the employee who is aggrieved, because conditional certification benefits plaintiffs, employees in the cases and the way it's currently being done, because conditional certification under the Equal Pay Act is a very low standard to be certified. So almost immediately in these cases, notices are sent out to employees, all employees saying, who wants to opt in? Who wants to be part of this case? If you do, all you have to do is sign this form, and you're part of it, and you move very quickly to the merits in trying to resolve the issue. What H.R. 7 would do is it completely changes that to a Rule 23 situation where you're going to debate for years whether those standards are appropriate, and then if so, look at mass groups of data for employees who never signed a form, who never said they wanted to be part of it, but didn't affirmatively opt out on a court document that they were given.
Very quickly, speak to the Chamber of Commerce versus Greater Philadelphia case. Would it apply to H.R. 7? If so, what would it do?
It absolutely would. It is on appeal to the Third Circuit. That's absolutely correct. The part of H.R. 7 that has the same flaw that was recognized by the court in Philadelphia is the part that says an employer can't ask.
So it's a free speech issue.
Absolutely. It's unconstitutional.
Thank you. Yield back, Madam Chairman.
Thank you, Ms. Byrne. This time I want to recognize the Chair of the Committee on Education and Labor, Mr. Scott, for 5 minutes.
Thank you, Madam Chair. Ms. Yang, in terms of EEOC pay data, what is reported now and what would be reported under the bill?
Thank you, Chairman Scott. The EEOC has for over 50 years collected data from employers with 100 or more employees based on race, gender, ethnicity, and job category to understand the total demographics of the workplace by a particular job. What the EEOC moved forward to do with the pay data collection was to strengthen that reporting so the agency would have a much more effective tool to identify potential pay disparities that the agency could then use its resources more effectively to investigate. And to answer the earlier point, the agency has robust confidentiality and security protocol in place, and the information that would be collected is in the aggregate. So it is not an individual person's pay information. It is just the total number of women, for example, in a particular job category with that pay.
And how logistically difficult would it be to provide this information?
We had an extensive process while I was chair of the EOC with public comment, 2 rounds of public comment. We also conducted our own pilot looking at these issues and heard from many sources. And we found that the burden on what we work to do is to minimize the burden on employers while also ensuring the pay data is useful for the agency's enforcement purposes. And I do believe the proposal the EEOC moved forward with struck a reasonable balance that imposed not a significant burden on employers.
Thank you. And we've talked about class actions, Ms. Yang. What is the present law on class actions, and how does the bill change it, and why is that important?
Thank you for that question. My understanding is the bill will actually strengthen workers' protections by giving them the choice to choose either the collective action provision that currently exists or to utilize the more modern Rule 23 procedure that applies to virtually all other types of claims in federal court. And the challenge with existing law is under the collective action opt-in procedure, it requires employees to file a notice with the court, which can be very difficult for employees to do because of fear of retaliation, or at the time they're required to file, they may not have any information about how their pay compares to other people, and they may not be comfortable filing that on record with the court. As a result, you often see perhaps 20% of all eligible women opting into the case. In contrast, a Rule 23 class action allows the class to be certified and gives individuals an opportunity to opt out later. The problem with current law is that it is often much less expensive for employers to just wait, to not look at their pay, and then if they're found responsible for discrimination, just to fix it later because the penalties are insufficient. And it shouldn't pay to discriminate, but unfortunately, under our current law, it does.
Thank you. And there's a change in damages allowed under the bill. How are damages in present law under the Equal Pay Act different for gender cases than race, religion, national origin?
The Equal Pay Act covers discrimination only based on gender. It provides the ability to get back pay. So the difference typically between the pay a woman received compared to the pay a comparable male received. And so in the cases where you can show there were willful actions, there is the opportunity to get higher damages, but it is still quite limited. So what the Paycheck Fairness Act does is provide meaningful remedies that will actually compensate workers for the full spectrum of harms that they suffer. And that includes compensatory damages, expenses that may have been incurred due to having to search for a new job, or medical expenses related to distress from the experience.
How does that compare for cases involving race discrimination, religion, or national origin?
So there are a number of protections under Title VII. Title VII prohibits discrimination based on race, ethnicity, national origin, and it provides compensatory and punitive damages. There are statutory caps that have not been adjusted, so those are well behind where they should be. And you also have the Reconstruction era statutes, including Section 1981, that prohibits discrimination in contracting, that provides a full scope of damages for compensatory damages as well as punitive damages without a statutory cap for intentional discrimination based on race and ethnicity, but there is no comparable provision based on gender.
And so this bill would just conform gender discrimination recovery to other cases?
Yeah, so this bill will fill that gap by ensuring that women who are facing pay discrimination have a full scope of relief.
Thank you. I'd like to recognize the gentlelady from New York, Ms. Stefanik, for 5 minutes.
Thank you, Chairwoman Adams, and thank you to all of our witnesses today for your thoughtful testimony. Women deserve equal pay for equal work, and in the United States, this is the law of the land. Since 1963, it has been illegal to pay different wages to employees of the opposite sex for equal work. Additionally, Title VII of the Civil Rights Act codified non-discrimination rules for employment, making it illegal to discriminate, including through wages, based on race, color, national origin, religion, or sex. The good news is that we have a strong story to tell of women's empowerment in today's economy. The number of women working in America is at a historic high of 74.9 million. And of the 2.8 million jobs created last year, nearly 60% went to women. We know that women are graduating college at higher rates than men and are increasingly their families' primary breadwinners. Let me reiterate my support of equal pay for equal work and voice my desire to strengthen this principle. To do this, we must understand what is actually happening. If you account for factors such as hours worked per week, rate of leaving the labor force, specific industry occupation, and length of time out of the workforce, the wage gap shrinks, but it is not completely eliminated. We must focus on closing this remaining gap. My concern with H.R. 7 is not with the overall goal, which I strongly support, but with how it goes about achieving this goal. I am concerned that aspects of H.R. 7 appear to be prioritizing trial lawyers, and in some cases, it makes it more difficult for businesses that are acting in good faith to rectify past wrongs and prevent future pay disparity. Despite these concerns, I want to lay out the principles of H.R. 7 that I strongly support, although I have some concerns about the current drafting. The principles I support are the following. I support the principle of allowing a job applicant to negotiate on the merits of themselves without being saddled by previous salary history. I support the principle of enforcing non-retaliation for pay disclosure by employees. I support the concept of providing workplace negotiation skills training to women. In addition to these principles, I support policies that I believe will help close this remaining wage gap, and we can look at particular governors who have effectively passed bipartisan legislation. I want to build on those current laws, and I want to ask a few questions to Ms. Olson. Ms. Olson, you discussed that today's employees are looking for flexibility in employment, and that increasingly means alternative forms of compensation outside of traditional wages. Could you elaborate on the potential benefits that allowing businesses to have protection for alternative compensation models would have?
Absolutely. It allows it to, in some, attract, motivate, and retain in the workforce longer men and women, all who may have unique needs that may not all be compensation-based, but may be based on other benefits of their working life as well as their personal life. And that's not a male-female issue, that's just a worker issue today. And in terms of what employers are doing along those lines is they're looking not just to have different types of payments in terms of wages and other elements of compensation, but also different benefit plans and different opportunities in terms of leave and other issues. And what employers are doing with respect to their own pay audits is really, many, many things. One being really looking at a lot of the data that's used is not necessarily digitized, making sure that they do audits and they create systems so that they actually can go back and be able to account for what are the differences in pay, reviewing it, also reviewing starting pay against what have you been paying people in those jobs that are in the workforce that haven't moved. Don't just pay the new people who are coming in because the market is high and people who've been with you for a number of years. So there's a holistic view of pay that's being done across workplaces today.
I want to follow up on that, Ms. Olson. You, as you just did in your testimony, point out that many businesses are looking internally to review their pay practices. And specifically in your opening statement, you discussed certain state laws that incentivize employers to self-audit their pay systems. Can you elaborate on that and why that is a successful model to close this remaining wage gap?
Yeah, it really is successful. A number of employers, unfortunately, are concerned that their own individual self-critical analyses or views and the way they categorize for statistical reasons different jobs and individuals, et cetera, could be used against them later. No good deed. By trial lawyers who say, well, you categorized it that way without maybe the benefit of all the information. So if an employer has to build their audit model toward, is this going to be subject to legal challenge or is it perfect in terms of that way, it's just so costly. You're using third-party statisticians and a lot of outside consultants to do that, whereas if instead an employer in good faith reviews their pay systems and also takes, and this is what these laws are saying, take good faith efforts for purposes of looking at what they have found and taking steps to eliminate pay differences, that there ought to be, one, a privilege with respect to that so it can't be used against them later. And the question isn't, did they come to the right answer, but did they do a diligent analysis and in good faith make good faith decisions with respect to it? It will encourage people. I definitely can represent that to these subcommittees. It will encourage more employers to do these audits, to make these changes voluntarily and quickly.
Thank you. Thank you for the flexibility on the time. I yield back.
Thank you. I recognize now the gentlelady from Pennsylvania, Ms. Wild, 5 minutes.
Thank you very much, Madam Chairwoman. Greetings to all of you. By way of background, before I arrived here in Congress just a couple of months ago, I was a litigator for 35 years and have been on both sides of these kinds of disputes. I have represented employers and employees who are claiming an injury in the nature of some form of discrimination. So this testimony has been captivating for me, and I read all of your testimonies with great interest. As a litigator, I was always most interested in making sure that there was a level playing field in the courtroom, and that my client, whichever side my client might have been on, was not walking into a courtroom with the deck stacked against him or her, or it, depending on the case. And that, to me, seems to be one of the most important criteria for this type of statute. So my questions are coming from that angle. So let me start with you, Ms. Olson. I wanted to ask you, have you ever represented an employee who has claimed to be injured by way of discrimination?
I have always practiced at business law firms that have represented employers with respect to these issues, but also represent them pre-litigation, where I view my role as coming to the right decision on behalf of that employer and analyzing all the facts, not as a person who's defending a position that's been taken, but determining whether, in fact, there is any evidence of discrimination. And I view that as my role pre-litigation and during litigation.
And when you are in the litigation situation, is it fair to say that you have always been there on behalf of companies or corporations?
That's absolutely true.
Okay. Your clients have a vested interest in this legislation. Is that fair to say?
I don't know what you mean by vested interest. I believe every American has a vested interest in making sure that we get this right.
Well, is it fair to say that the vast majority of your clients would not be happy if this legislation was passed?
I don't believe the vast majority of Americans would benefit from this legislation.
Well, let's stick with my question, okay? Your clients, let's just talk about your clients. Is it fair to say that most of them would be very unhappy if this legislation was passed?
You know, I can't answer for them. I haven't asked them that question. I don't believe the legislation works in today's workplace. So my opinion is that I don't believe that it would be beneficial to any small, medium, or large employer.
And you believe that the current state of the law provides for a level playing field, don't you? You've stated in your written testimony that plaintiffs already take advantage of the system by filing discrimination charges. Therefore, the Equal Pay Act must be enough.
I haven't said that the Equal Pay Act is enough. I've provided 3 examples of improvements or enhancements to the Equal Pay Act that I believe would enhance it.
Okay. Would you agree with me, the data that we've received from the EEOC indicates that employees filed almost 85,000 charges of discrimination in 2017, and the EEOC legal staff filed just 184 merit lawsuits alleging discrimination. Does that sound about right to you?
It absolutely does.
Okay. And you believe that the rest of those charges that were not accepted by the EEOC evidence some sort, frivolous claims? Unwarranted claims?
No. No, the charges that are filed, many of them continue an investigation. Many of them are resolved through settlements, and others are dismissed for lack of substantial evidence as found by the EEOC investigators.
All right, but you would agree then that just 0.2% of claims are actually prosecuted by the EEOC, yes? So yes or no?
The answer to that is yes.
Okay. I'd like to move on to Ms. Yang, if I may. Ms. Yang, can you address the concern articulated by my colleague on the other side of the aisle that the Paycheck Fairness Act will open the floodgates for litigation by providing for uncapped punitive and compensatory damages, even where there's no showing of intentional discrimination?
Yes, I know that there's out of time, but if I have time, I'm happy to answer that question. I think it's important for us all to step back for a moment and recognize the rigorous prima facie case that a worker needs to establish to even get to the point of the defense. Courts have required employees not just to show a pay difference between a man and a woman, but to show that those jobs are substantially equal in terms of their skill, in terms of their responsibility, in terms of their effort. And that is a rigorous standard to meet. Employees also need to show that they're working under similar working conditions. So it is only after the employee has shown all of these things, which is actually higher than the Title VII burden of proof on a worker under the similarly situated standard, right? It's only after you've shown that the employer gets to try to put forward this affirmative defense. And it is appropriate to require that defense is a business necessity because the employee has already shown that they're doing the same work. So if the employer is going to justify paying one gender less than the other, it needs to be able to explain a sound business reason for doing that. Courts have been interpreting that standard of business necessity since 1971, the Griggs versus Duke Power case, and in 1991 it was codified in the Civil Rights Act of 1991, which amended Title VII. So it is a well-established standard.
Thank you, Ms. Yang. And if I just may, I know we're over time, but the trial lawyers are the ones that help the employees who claim to be aggrieved. Is that right?
Absolutely. This Paycheck Fairness Act is about helping workers. Anyone who says this law is working now is not appreciating how much risk employees take on to come forward, to sue their employers, to litigate for years and years, to have courts deciding that bias factors justify a pay disparity, right? Even if some courts are getting it right, that is a real hardship for those workers who have to go through that process.
Thank you, Ms. Yang. Thank you, Madam Chairwoman, for your indulgence.
Indeed. I next recognize the ranking member of the full committee, Representative Fox from North Carolina, for her questions.
Thank you very much, Madam Chairman. I thank the witnesses for being here today and for your testimony on a very important issue for women and all workers across the country that's a topic of discussion today. Pay discrimination based on sex is illegal and should not be tolerated. I also strongly agree with previous statements made today that women deserve equal pay for equal work. Ms. Olson, the Equal Pay Act and Title VII of the Civil Rights Act prohibit pay discrimination on the basis of sex and equal pay for equal work and have been the law of the land for 55 years. From your significant experience in studying this issue and from your legal work in this area, are employers mindful of their legal responsibility not to pay different wages based on the sex of the employee? What steps do businesses of all sizes take to ensure they're not discriminating based on sex in how much workers are paid?
In my experience, employers have a deep commitment to ensuring their compensation systems effectively attract, motivate, reward, and retain employees while complying with applicable laws that you've described. Complexities exist because job-related factors such as seniority, work performance, prior experience, relevant credentials, competitive offers, and other job-related factors exist between employees who perform the same work. Some of those are quantitative, some of those are qualitative issues. Some of those are contained by their nature in HRIS systems, some of those are not. So what employers are doing today in terms of taking good faith efforts to comply, I mentioned the conduction of pay audits. That is happening across the country. They're also doing individual employee level adjustments in connection with those audits. I also mentioned they're reviewing all starting pay decisions in comparison to other pay within the workforce. There's also something that I'll describe as the information gap. And employers are trying to change that to make sure that they have documented and even digitized in their workforces information regarding what are the variables that are changing and affecting pay. They're educating and developing managers regarding legitimate business reasons that are to be used with respect to particular issues. They're building new compensation structures with ladders within those particular jobs to make sure that everybody understands that maybe a difference in experience or performance is what is putting you in a ladder going up that relates to the pay you're getting. Those are some of the things that employers are doing.
Thank you. Ms. Olson, H.R. 7 directs the EEOC for the first time ever to collect employee pay data from employers broken down by the sex, race, and national origin of each employee. This provision is a reprise of the rejected Obama administration proposal to add pay data to the EEO-1 report, which I raised concerns about when it was under review by OMB. The Obama proposal would have increased the data fields provided by employers in each EEO report 20-fold, from 180 to 3,660. That's an astonishing figure. At the time, it was also estimated that adding the employee pay data to the EEO-1 would bring the overall cost to employers would have to bear to approximately $700 million annually. Ms. Olson, do you agree that requiring additional employer reporting to the federal government involving employee pay data would not only create huge compliance costs, but will also raise significant privacy and confidentiality concerns for workers and businesses alike? And if so, can you expand on these and any other concerns with this mandate?
Thank you, Representative Fox. I can, and I actually was one of those witnesses that testified before the EEOC with respect to the expanded EEO-1 and also relied on specific survey and economic data regarding the actual burden that employers reported that expanded pay data that you described would really impose with a complete lack of utility or benefit. And let me just give you an example. That form would have required, for example, a hospital to provide data with respect to men and women within the position of profession, without regard to what job they held. They might be a pharmacist, they might be a lawyer, they might be a doctor, they might be a nurse. But if there were any differences generally between pay between men and women within that category, without regard to the job they held, that would be used. That's the kind of information that has no utility, that kind of information I just described. In terms of the burdens, the burden initially estimated by the EEOC when it was introduced was about $5 million. After our testimony, the EEOC increased the burden and said, you know what, I may have been wrong. Maybe it was about 20 million. And the data that we collected showed that it was at least 700 million, the number that you used. And in terms of privacy concerns, the EEOC's response to those issues, which was required under the Paperwork Reduction Act, was that we'll get to that.
Thank you. Madam Chairman, I didn't have time to ask a question about the Harvard University study on Massachusetts Bay transportation, but I'd like to enter that into the record.
Without objection.
Thank you, Madam Chairman. Thank you for your indulgence.
Indeed. I now recognize Representative McBath from Georgia for 5 minutes for her questions.
Thank you to the chairs for holding this hearing today, and I'd like to thank the witnesses for being here and for your prepared testimonies and remarks. I am proud to be an original co-sponsor of the Paycheck Fairness Act, and I think most of us can agree that every American should earn equal pay for equal work. As of January 2019, the median annual wage for women and men in the 6th District of Georgia, where I reside, was $53,351 and $75,837 respectively. That amounts to a $22,000 difference. This gender gap is most clear, and I'm glad the Paycheck Fairness Act would address this issue. Not only would this legislation help women in Georgia, this will also help families across the nation. I'd like to learn a little bit more about the impact of the gender pay gap, and so Ms. Graves, could you please answer this question for me? What impact does education level, whether that be high school, secondary, or post-secondary, have on the gender pay gap?
Thank you, Congresswoman. One of the things that has been studied and studied again is whether or not it is possible to totally eliminate the gender pay gap if you control for things like education level, if you control for things like geography, if you control for unionization, a range of things. And although the pay gap does shrink when you control for education level, it's just impossible to eliminate no matter how much you control for it. There is a large portion of it that remains unexplained and likely due to discrimination. And one of the reasons that we know that is that there is a number of studies that have followed people right out of college. AAUW has a study like that, where they have looked at people straight out of college, and within a year of graduating from college, even when same major, still a pay gap.
Well, thank you. Could you also speak to what impact paid family and medical leave has on the gender pay gap?
One of the things that we know is that the pay gap is due to discrimination in the same job, but is also due to other things, like the fact that there's what we like to call a caregiver penalty. And so the full suite of solutions to really finally make sure that we don't have a situation where Latinas are losing $1 million over the course of their lifetime, or $22,000 in Georgia 6, is going to include things like Paycheck Fairness Act, but it's also going to include things like finally having a national paid family and medical leave program. So passing things like the Family Act will make a difference. Actually raising wages so that we, for the first time in over a decade, raise the minimum wage, right, and have one fair wage. All of those things will help to contribute to lowering the pay gap so that we do not have a situation like we've had in the last decade where we have barely budged.
Thank you. I'm also very struck by the section of the bill that would establish and run grant programs to carry out negotiation skills training programs for girls and for women. So Ms. Graves, could you expand on the impact this will have on the gender pay gap as well?
I mean, one of the things that we know is that a lot of employers rely on negotiation as a part of their salary setting process. And study after study has shown that the problem is that employers see men and women who negotiate differently, right? When men negotiate, they kind of like it. When women try to negotiate, it turns out they don't think they do so well. So some of that is bias and stereotyping. But one of the things the Paycheck Fairness Act would actually do is give women more tools, give people tools so that they understand how they'll be perceived when they negotiate.
Thank you so much. I yield back my time.
Thank you, Representative. And before I recognize the next member for questions, I request unanimous consent to submit for the record a letter from Virginia Lipnick to Donald McIntosh, Kimberly Esserly, dated May 25th, 2017, with the subject responses to the Chamber and EEAC critics of the EEO1 pay data collection, and a letter from Virginia Lipnick to Peggy Mastroianni, legal counsel, titled EEOC's response to EEAC's argument that relevant circumstances have changed after OMB's approval of the EEO1 report. In that letter, which was recently discovered in response to a FOIA request from the ACLU, Ms. Mastroianni, in fact, informed Ms. Lipnick that there were, in fact, no significant change in relevant circumstances that would provide OMB with an independent basis to reconsider and issue the stay. Without objection. And I now recognize Mr. Johnson from South Dakota for 5 minutes for your questions.
Madam Chair, thanks so much. I'll start by stating the obvious that equal pay for equal work is just and it's appropriate. I'm proud that it's the law of the land under the Equal Pay Act. That pride doesn't blind my eyes to the fact that there are opportunities for improvement, of course, and that's where I would like to start. Ms. Olson, you referenced in your testimony and also alluded to under questioning by Ms. Wild some areas for improvement. And I guess the one that I want to learn a little bit more about is you talking about making sure that that there's a requirement that the pay differential is linked to some job-related or site-related factor. I assume that would add to the predictability and the clarity and the common sense application of the Equal Pay Act, but I'd like you to teach me a little bit more about that.
Thanks very much for your question. Yes, currently the Equal Pay Act language says any other factor after a list of job-related factors, many of them that have been talked about today, and any other factor other than sex. That language, based on principles of statutory construction, and the majority of circuit courts that have looked at it have said, well, that other factor has got to be job-related. But there have been a couple of courts that have said, well, it's got to be uniformly implied, and it's got to be the real reason, but I don't know if it necessarily has to be job-related. That's a very, very small minority view. Employers look to both development and education of managers who do interviews and also human resource executives, that they make sure that their decisions are based on what is oftentimes called LBRs, legitimate business reasons. And that's really what the courts have looked to, and inserting that so that there is no question. It's absolutely expressed in the statute, I believe would be welcome and is appropriate.
So give me some sense. Now, it seems as though maybe the prevailing set of case law has kind of moved away from illegitimate business reasons, right? I mean, give me some sense of what may... Go ahead, sorry.
Yeah, I'm sorry. So I think I understand your question. It's not that an illegitimate business reason was ever appropriate. So to go back to what the Equal Pay Act is, it's a strict liability statute and the only employment discrimination statute in the United States that says, show me a difference in pay between two people doing the same thing. You don't have to prove discrimination. Just show me a difference in pay. An employer, you don't have the burden of production in the law. You have the burden of persuasion. You have to not articulate a legitimate business reason. You've got to prove it. That's what the Equal Pay Act currently says. And so here, examples would be job performance. Examples would be experience that would be relevant. But relevant experience isn't something that's usually documented and digitized in a system. It's something you learned from talking to someone or was on their resume. So emphasizing that those job-related reasons are the ones and the only ones that you can rely on is something that I think will also further the proactive employer actions that I've described in terms of what we all want, which is equal pay for equal work.
That's very illuminating. Thank you. I want to shift a little bit to retaliation, and that is prohibited by the National Labor Relations Act. But I want to get a sense of how the law today around this equal pay issue differs from that, and then how the proposed legislation would deal from the National Labor Relations Act.
Okay, thank you very much. And it's not just the National Labor Relations Act. There are many, many statutes, and I've cited them in my written testimony, including Title VII, that says you can't be retaliated against for discussing. It's not just participating or opposing a pay practice. And if you go to the EEOC website today, you'll see the long list, which I've included in my testimony, of all the different type of discussion actions that the EEOC has listed as protected under existing law. So you've got Title VII, you've got other non-discrimination like GINA, for example. You've got the National Labor Relations Act that protect reasonable actions taken by employees for a appropriate purpose, for learning, for discovering, for trying to understand, is there a difference? What HR 7 does, it says, Anybody can talk about anybody's pay with no restraints, not for a reasonable purpose, the purpose in terms of furthering equal pay, any reason. So you could just post everybody's name and pay rate on social media, and if somebody did that, an employer couldn't take action against them? That's what currently H.R. 7 would allow.
Thank you very much. Thanks for your courtesy, Madam Chair. I yield back. What time I don't have.
Thank you, Representative. I now recognize Representative Dr. Schreier from Washington for her questions.
Thank you. Thank you, Ms. Chair, and thank you to all of our witnesses. I'm very grateful for coming, and I am excited about hearing more about pay equality. Just this morning, I, as the first pediatrician in Congress, had the opportunity to meet with a whole bunch of groups who all advocate for the welfare of children, whether that's education, healthcare, you name it. And a question came up that was about the intersectionality, really, between poverty and food insecurity and housing insecurity, education, healthcare, school outcomes, even kindergarten readiness, and we all in that room understood that. And so my question is to you, Ms. Rowe-Finkbeiner, about, is there such an advocate for moms, if you could talk about poverty in homes where there is a single working mom, and what Paycheck Fairness Act would do to change the living situations and the ultimate outcomes for those families and for the kids.
Thank you for the question. It's a good one. Right now in the United States of America, when we're looking at women's wages and what's happening with women, we have to take a step back and look at what's happening with pay equality. So right now, over 90% of people who are women are making less than $75,000 a year. And half of those people who are women are making less than $30,000 a year. Single moms are experiencing the most extreme wage hits. They're making around 55 cents to a man's dollar. And so when we look at what happens with families, we look at what happens with our economy, we see a tremendous problem. If women had pay parity, we would drop poverty in families by 50%. This is huge. This is needed. This is necessary. 1 in 5 children in our country right now are experiencing food scarcity due to family economic limitations, and family structure has changed. I want to say that again. Family structure has changed. A Johns Hopkins University study found that 57% of births to millennials were to single mothers. So when we're looking at what happens with the confluence of the wage hit, of what's happening with parenting, of what's happening with children, what's happening with our country, we have to get to pay parity. And we have to get to pay parity because it helps businesses. Again, remember, when we have more women in leadership, businesses thrive. It helps families. When we pull families out of poverty, we have children becoming the leaders of tomorrow. It helps women because when we are actually having enough money to spend, we then, in turn, help our economy. I want to step back. I love your big question because I always have big answers, but I want to step back and remind people that women make 3/4 of consumer purchasing decisions. An economy that is 72% of our GDP is based on consumer spending. So when we have women having such extreme pay hits, we have extreme harms to our children's health, to our economy, and to women. And this is a really big deal to solve, so I'm so excited that we're all here today to solve it and to finally pass the Paycheck Fairness Act. Thank you for your question.
Thank you. I may have another one for either you or for Ms. Gosgraves. You can battle this one out. So this is a personal story that I have for the past many years enjoyed, I think, pay parity because as a pediatrician, my pay was based mostly on my productivity, and here I have equal pay. But I have to tell you that coming out of residency, I was so excited to earn more than $4 an hour that when I was offered my first job, that's right, when I was offered my first job, I just immediately accepted. It never occurred to me to negotiate. That was what was offered, and that is what I would accept. So I just have to ask a bit about, to either one of you, about the negotiation skills training and what that looks like and how that helps, and do you have any empiric evidence on what kind of gap that could make up for women who are just entering a first job?
The negotiation training is important because it's going to give people more tools and remind them to ask and to ask for more, for sure. But it's also just important to remind people that we can't fully negotiate our way out of pay discrimination. And so it is a piece of a broader approach that ends the many, many practices that employers are giving. You know, I would say that, you know, your employer who set your first salary perhaps far too low probably takes some responsibility there too, especially if there was someone doing exactly what you were doing, but making a lot more.
I will never know the answer to that question. Thank you very much.
Thank you, Representative. I next recognize Representative Hayes from Connecticut for her questions.
Thank you, Madam Chair. Actually, I'm going to yield my time to my colleague, Congresswoman Susan Wild.
Representative Wild.
Thank you, Congresswoman, for yielding your time to me. I'm going to continue with my theme of leveling the playing field. And I want to elaborate on the last comment that I made after Ms. Yang testified in response to my question. My experience over 30-plus years of being a litigator, most of which, by the way, Ms. Olson, was on the defense side, meaning I represented the companies or people who were being sued by somebody represented by a trial lawyer. And for anybody who doesn't know, trial lawyer is commonly used to refer to lawyers who represent plaintiffs. But in my experience, far from being the villains, almost every trial lawyer I encountered was the only hope for a plaintiff who was unsophisticated, didn't understand the law, and had no hope of pursuing a legal claim without the expertise of his or her lawyer. Our legal system is dependent on having lawyers who will help individuals who are unsophisticated in the law or who do not know their legal rights. So, for instance, when my colleague on the other side of the aisle, Mr. Johnson, was talking about retaliation being forbidden, and Ms. Olson was engaging in the dialogue with him, the only way an employee would be able to pursue a claim of retaliation is with the benefit of a trial lawyer to help him or her. So, with that said, I'm going to ask Ms. Roe Finkbeiner, in your testimony, you shared an interesting perspective, and we're going to shift gears a little bit to class actions. As you may have ascertained, I like to get into the weeds on this legal stuff. But I was drawn to your testimony on why it's important to amend the Equal Pay Act to change the class action to be an opt-out standard, similar to the standard under Title VII and under Rule 23 of the Federal Rules of Civil Procedure. From the perspective of the women that you've engaged with, why is it important for them to be able to band together in such actions? And maybe you could just explain that a little bit for those who aren't familiar with the opt-out standard.
Well, we need to remember again who is being impacted the most by unfair pay, to your question, which is low-income women. The lower your income, and 3/4 of minimum wage workers are women, the more significant you're going to be impacted by wage gaps. And so for lower wage women workers, automatic inclusion in class action lawsuits is vitally important because it is also in those job positions that you are most vulnerable to retaliation. The moms of America that we hear from every day are telling us their story about their unfair pay. They're telling each other their story about unfair pay. But they are absolutely afraid to step forward and talk to their employer or to take action or, much less, afford an attorney. And this is very important because if we don't have this inclusion, if we can't stand together, then women have to stand up by themselves and say, I am experiencing unfair pay. And let me tell you, that does not go well. We hear from the moms of America what happens when they stand up and they lose their jobs, or they're told, you know, it's this or the highway. And so we hear that again and again and again, and what that says is that the current law is not sufficient. What's happening right now is not sufficient. We have right now experiences where we have moms with equal resumes on pieces of paper, not actually in person, getting hired 80% less of the time than non-moms. So current law is not sufficient. We need to be able to band together. We need to be able to protect women from retaliation, and the way to protect women from retaliation is to have an inclusive group rising together, and that's absolutely needed, as shown by the horrifyingly horrible pay gap data that we see right now today.
And just to be perfectly clear, opt-out would mean that they would be included in the class unless they chose to opt out, if they were discriminated against. Is that correct?
I want to defer to Ms. Yang, who is an attorney.
Okay, and I'm going to ask Ms. Yang a question anyway, so she can address it in response to this. Prior to your time at the EEOC, you spent 15 years litigating equal pay and other discrimination cases on behalf of employees. And litigation is obviously very expensive, especially with the threat of the prevailing party recovering attorney's fees. And that often scares off aggrieved workers. Would you agree with that?
Yes.
Okay. Could you discuss, please, how, in your experience, employers use the prevailing party doctrine to extort or deter aggrieved workers' claims, and how the Paycheck Fairness Act levels the playing field on that issue? And at the same time, perhaps you could address the question.
And before you answer, Ms. Yang, the time has expired and the hour is late, so I'm going to ask you to submit that response to the record because we still have other members who have not yet asked their questions. So
thank you, and I apologize, Madam Chairwoman.
No worries. The response can be submitted for the record. I next recognize Representative Stevens from Michigan for her questions.
Thank you so much, and thank you to our distinguished panel today for testifying and sharing your expertise on this critical topic around wage disparities and gender wage disparities. As somebody who has spent their career in workforce development and STEM education, and particularly girls' STEM education, I couldn't think of a more pertinent topic for our new Congress in this historic moment, 100 years from when women got the right to vote to now having the most number of females serving in the body, that we bring this topic to the fore in this legislation to the floor of the United States Congress. And so my first question is for Ms. Goss-Graves around the value of work and the value of human-driven work. And in particular, in your testimony, Ms. Goss-Graves, you talked about 60% of employees in the private sector report that discussing their wages is either prohibited or discouraged. Why is that the case? How do these policies inhibit workers from adjudicating pay discrimination claims?
So there's a lot of secrecy already around pay, even before you add on punitive pay policies that some employers put in place. So if an employer puts a policy in place that says, if you talk about your wages with each other, if you report what you're making to anyone, you can be fired, or you're violating a rule in some way, it means that people are less likely to do it at all. That's what happened with Lilly Ledbetter. That's why 20 years went by and she didn't know that she was making so much less than everybody around her. So for those workplaces, what you have seen now is some employees really saying, I'm ready to talk to people about what I'm making, because right now all of the pay information lies in the hands of an employer.
Mm-hmm. Well, and we've also seen that we are at some of the lowest levels in union participation and in union organizing. And I was wondering, depending on your knowledge, if you could kind of comment a little bit around the importance of being able to collectively bargain and to having a strong labor unionizing presence in the workplace.
I mean, one of the things that we know is that union workplaces have lower pay gaps. Right, have smaller pay gaps. So we know that part of the effect of unionization is having both more transparency around wages and an ability to have some collective shifts. It doesn't eliminate it entirely, right? You still need more, but it is some protection, and the fact that we have seen attacks on unions just at the same time that we have seen a wage gap not really budge in so many years is really related. I just want to raise one more point that I forgot to raise earlier. The anti-retaliation provision in the Paycheck Fairness Act, it does not require that workers go around saying their wages, right? It is just that you can't be penalized if you're talking about your wages. There's a big difference there.
Yeah, great. Well, we are certainly here for the working families of this country, and the working men and women, and to make their lives better, and to protect their taxpayer dollars and what's going into their pocket versus what is not. And Ms. Rowe Finkbeiner, I was wondering if you could answer quickly for me, what is the wage gap between working mothers and working fathers? And if you could just delineate between single working moms, if you have it, and single working fathers, and married mothers versus married fathers.
That's an excellent question. Moms are making 71 cents to every dollar that dads make. And then when you look at what's happening with moms of color, they're experiencing increased and significant wage hits on top of that. And so when we look at the impact of that on the family, we see that we have children significantly suffering as well as moms and families.
Yeah. And why, so just if you could shed a little bit of light from your vantage and your background, why is it important to encourage negotiating skills and training programs for women and girls as the Paycheck Fairness Act does? Why is it also important that we remedy the flaws in the Equal Pay Act?
It's absolutely essential that we eliminate the flaws so that our economy, our families, and our businesses can thrive. And I just want to go back to what's happening with moms. Why are we experiencing these wage gaps? What's happening with women? What's happening with women of color? And there are a lot of implicit bias decisions happening over and over and over again. And training can help shine a bright light on that and eradicate that. So we need things like the Paycheck Fairness Act. We also need to move forward a stronger infrastructure for working families in the United States of America. That includes passing the Family Act, which was introduced yesterday, passing the Healthy Families Act, which is sick days, making sure childcare is more affordable. Childcare costs more than college in the United States of America right now. Making sure that you have a livable wage for everyone, including tipped workers. So we need to move forward infrastructure that's strong for families, that includes the Paycheck Fairness Act, and that allows our taxpayer dollars to be well spent. One of the things I didn't mention is that TANF dollars would be significantly decreased if we have pay parity. So we see that if we have pay parity, we will save taxpayer dollars. Businesses will be happy. I'll be happy. Women will be happy. And everybody will celebrate. So we really hope that you pass the Paycheck Fairness Act yesterday.
Fabulous. Well, just as I'm about to yield back the remainder of my time, I will re-emphasize how important and vital your voices are here today. Thank you.
Thank you, Representative. Now I recognize Representative Omar from Minnesota for her 5 minutes.
Thank you, Chairwoman. Happiness and prosperity for all is a really exciting conversation to be part of. I am grateful to all of you for being here and for being part of this critical conversation that will move us towards getting prosperity for all. Ms. Gross-Graves, it's great to see you. I know that you brought intersectionality into your testimony, and in it you addressed that the pay gap is actually greater for women of color. The statistics you shared on increased pay gap for Black, Latino, Native American women were quite shocking. 61 cents to the dollar for Black women, 53 cents for Latinos, and 58 cents for Native American women. Clearly, the pay gap is compounded by racial gap. And it should be obvious to all of us that this is a problem that extends beyond the workplace. You see the impact everywhere you look in our society. Women of color are less likely to have quality of healthcare coverage. A little more than 20% of households of color experience hunger. And at some point, that doubles the rate of white households. When it comes to planning for the future, working women of color are much less likely to have access to employer-sponsored retirement plan. And home ownership rates among people of color are also comparatively low. In fact, in Minneapolis, the city that I represent, was listed as having the widest gap when looking at white and black home ownership rates last year. Minneapolis in Minnesota is also one of the most segregated, and you know, when it comes to the racial disparity gap, is among the highest. So I ask you, do you agree that the gender gap is not only holding us back as Black women, but amplifying racial inequalities?
There's no question. You know, I wake up thinking about this. The idea that Black women make only 61% of white men's wages, that is an issue for them, yes. It's an issue for their full families, and Black women are more likely to be sole or co-breadwinners. So it is an issue automatically. Their salaries is for them, but it's also for their families and its entire communities. It ties to whether or not people have health care. It ties to whether or not people are really able to actually afford the child care they need to work in the jobs that they need. It ties to whether or not communities could be collectively stable and really thrive. So it is dealing with this issue, which is a fundamental issue of discrimination, but it's a fundamental issue of economic security and justice more broadly.
And so when we are addressing equality in this country, this is, right, as an immigrant, as a refugee, all I heard about was the access to justice and equality in the United States. But it seems like we often forget to address that in our policies. And so by implementing this, how do you see that it will systematically change the way we see ourselves as equal members of society?
You know, when Congress first passed the Equal Pay Act, that's really what they were saying. They were saying, if you're doing the same job, you deserve to be paid the same wage. And what we have learned over the last 5 decades is that we did not go far enough. Our law wasn't effective enough. So part of what passing the Paycheck Fairness Act right now would do is send a really loud signal, not just to employers about their conduct and the requirement that they pay people the first time, but really to women in this country, and especially women of color in this country, that they are seen, that they are valued, and that their right to be able to work with dignity and with equity is a core value to this country and to this Congress.
Because, you know, I know that we've talked about this before. Empowerment really isn't about just saying, right, that we deserve access to equal things, but it's also about removing the barriers that allow us not to be empowered and to be equalized in society. So I thank you all for your testimony and appreciate this critical conversation we're having in bringing prosperity for all.
Thank you, Representative. I now recognize Representative Trone from Maryland for 5 minutes for his questions.
Thank you very much. I appreciate you coming out. Mrs. Goss-Graves, we heard earlier from Congressman Don Beyer on the first panel that pay equity makes good business sense. That makes all the sense in the world to me. But investing in policies that ensure equity between men and women is simply good for business. Companies that hire and retain's key. More women gain a competitive edge. Diversity of thought leads to better problem solving, better ideas, better decisions, basically better results. That's a win-win for everybody. So what are some other factors that make pay equity, you think, good for business? Because we're talking a lot about the team member, but on the other side also.
One of the things that happened a decade ago when this Congress passed the Better Fair Pay Act is that new attention and awareness to equal pay happened as well. And so now people are thinking about it and concerned about it. And employers know that in order to recruit and retain top talent, they have to be paying fair wages. And so that is an important incentive that is out there and that is driving some employers. That's why more than 100 employers signed the White House Equal Pay Pledge. It's why you have seen some people not just do pay audits, but then announce the results, right? They've said, I just wanted to tell everyone that I've done an audit, and we pay fairly, because they know that consumers care about it and that the people they're trying to recruit and retain care about it. And I wish that you could always just legislate for like the handful of employers who are going to, do the right thing and only be motivated by those things. I think what's happening right now is some employers are making decisions that are not good for business. They're not good for workers by allowing discrimination to thrive.
Excellent. Agreed. Mrs. Yang? No one's arguing we shouldn't allow pay differences based on education, training, experience. The Equal Pay Act already allows it, and the Paycheck Fairness Act would not change that. But the law exists now, says without clarifying that factors other than sex must be job-related. Seems to me that can be used as a pretext for discrimination. Am I wrong about that? And why is it important that employers use factors other than sex to be connected to legitimate business reasons?
Thank you for that question. You are not wrong. Currently, courts have allowed employers to justify pay differences between men and women doing substantially the same work in the same working conditions by reasons including random decisions as well as reasons that themselves had bias. And we've heard about some of that today, the ways in which negotiation can be conducted in a way that actually disadvantages women. So even when women try to negotiate, they can face a backlash. She should just be happy she has this job. Who does she think she is? That is very real for women in the workplace. And when we see prior salary relied upon or other sort of unspecified market forces, what you often have is that individuals who may be people of color, they may be underpaid in the market for a variety of reasons. So you're introducing both discriminatory factors into the next job as well as random factors. And all the Paycheck Fairness Act is trying to do is get employers to really pay attention to what is the consequences of the pay system that they set up and are responsible for. So it's important for employers to actually look at whether the skills and experiences they're valuing truly are related to the job, because sometimes they're not. And this requires employers to take that step, which they should already be taking, but unfortunately not often enough. Often it's easy to rely on legacy practices. We think we know that this type of personality will be successful, but in fact, when you look at the data on what kind of prior experience and skills correlated with, say, your best salespeople, it might tell a very different story than the system you set up. So this really just encourages employers who are in the better position to understand how their system works, to take that proactive action and set up fair pay policies, rather than putting the burden on individual workers who are in the least safe position to address these issues.
Excellent. Thank you. I yield the balance.
Thank you, Representative. I now recognize Representative Lee from Nevada for 5 minutes for her questions.
Thank you, Chairwoman, for having this hearing, and thank all of the witnesses for being here. I am from Nevada. I've had a career in helping our most at-risk students graduate from high school. And we have found that the most significant risk factor for students dropping out is poverty. I actually sat through a hearing yesterday, sort of rivaling this one in length. I think it actually beat it. I'll get quicker so we can beat it. That focused on investment in education. A number of my colleagues across the aisle continually raise concerns that despite increased investment in education, our schools still continue to struggle. A recent study by the National Center for Children in Poverty found that close to 43% of children live in families with incomes that are insufficient to meet basic needs. And given that 63% of women are in sole breadwinner or co-breadwinner in their families, I'd like to ask Ms. Goss-Graves, can you comment on how this wage gap perpetuates intergenerational poverty and ultimately educational outcomes for students?
Well, we know that 1 in 8 women live in poverty, and those numbers look worse for certain groups of women of color. And the ability to have wages that are fair and that and this longstanding wage gap that we have that has not shrunk in the last decade in any way that's meaningful is absolutely tied to the ability for people to live out of poverty, I'll say. And that's especially given the extra penalty that people who are mothers or people who are caregiving generally face. So just as people are transitioning into parenthood, as fathers sometimes get a pay bump, mothers get a pay cut, right? When there have been studies that show that people view mothers and value their abilities less and pay them less. So all of that combined, when you add to it the fact that we are lacking the range of policies that would really make it possible for people to work and to care and to thrive, it makes it a real challenge. So the Paycheck Fairness Act is a critical piece of the range of things that we need to do to reduce those poverty rates that you've named.
Thank you. Ms. Rowe Finkbeiner, would you would like to add anything to that?
Yes, I think it's important to look at what's happening with women and wage hits. And so I referenced this study that I love a little bit before. I want to share a little bit more about that because it really shares what's going on in America. Cornell University did a study. They had 2 resumes with equal job experiences, equal everything. And the mom was hired 80% less of the time than the non-mom. And to Ms. Goss-Graves' point, the dad was hired more. The mom, for a highly paid job, was offered $11,000 less. The dad was offered $6,000 more. Right now, when we look at the structure of family in America, the nuclear family is a thing of a past, if it ever even was really a thing. And we know that we have to have the wages of women to boost our economy, to lift our children, and importantly, now I'm on a roll, we have to make sure that our prior wages aren't used to predict our future wages. And this is one of the things that's critically important in this bill. We cannot have our past salary be used for future wages. Because if we are working our way up, if we are facing an uphill battle in wages and discrimination, and there is massive hiring and wage discrimination, then that past salary history being used to predict future history just puts us in a cycle of poverty. So that is a key, essential part of the Paycheck Fairness Act that we 150% support at Moms Rising, and the million members of Moms Rising are cheering right now just knowing that you're considering it. So thank you.
Just want to add, in Nevada, if the wage gap were closed, women could afford 56 more weeks of food for her family or 8.5 additional months of rent. Given those statistics, could you comment on what the impact of closing the wage gap would be on retirement savings and Social Security? Ms. Rowe.
Over a woman's lifetime, depending on where you are in the pay scale, you're losing $400,000 to $2 million over your lifetime due to the wage gap. This means that we have a significantly higher number of women who are elderly living in poverty than men who are elderly living in poverty. And so if we close the wage gap, it's actually intergenerational benefit to women and to our economy and to our families. And as we look at what's happening with our country, we're facing a silver tsunami where we have a massive aging population. And it's time right now to make sure that we close the wage gap before it's too late. I mean, it is already too late for many families, but it's getting worse, not better. And to the many points that have been raised in this room about is prior law sufficient, it's absolutely not sufficient. And in fact, as we are looking at an economy where we have greater and greater gaps between the very wealthy and everyone else, the wage gap is becoming a more dire, more emergent situation for the families of America that we must solve now. So thank you.
Thank you. I yield.
Thank you, Representative. I now recognize Representative Underwood from Illinois for 5 minutes for her questions.
Thank you, Madam Chair, for the opportunity to join this panel. And thank you to our witnesses for being here today. Ms. Goss-Graves, I want to thank you and the National Women's Law Center staff who came by to brief me on the Paycheck Fairness Act last week in preparation for the hearing. Thank you for that as well. The gender pay gap in my district is shockingly bad. For every dollar that men in Lindenhurst or Sugar Grove or even Shorewood make, women make 71 cents. And Ms. Goss-Graves and Ms. Lang, how quickly are we making progress on closing the gender pay gap?
In the last decade, we haven't made very much progress at all. You know, it has inched up like a penny. You know, and so what we really need is sort of a bit of a shot in the arm to actually get this going and closing now. So we're not making the progress we need.
Okay. Ms. Yang, did you have anything to add to that?
I think that one of the important things that we need to remember about this Paycheck Fairness Act is that right now we're letting equality be left to chance, right? At the EEOC, we did not hear from the overwhelming majority of people who were experiencing pay discrimination. You can see the data in your own district that there are problems, but we at the agency were hearing about things because of happenstance. Somebody found a paper on a copier that had salary information. Somebody sent a misdirected email. So we were relying on happenstance to learn about discrimination. So it was vital to me at the EEOC that we move forward with the pay data collection because that would shine a light on the problems. And to the point earlier Ms. Olson made about the utility of the data, we carefully studied. We had a pilot effort, we had 2 rounds of public comment to ensure that that data would be useful to the agency. And if you had, for example, a hospital, you would see that we have pay bands. So doctors would be at the top, higher pay bands, nurses would be in different pay bands, and the EEOC has decades of experience looking at this data. We've used it to successfully identify patterns of hiring discrimination by looking at demographic differences as well as promotion, where often we may see African Americans are hired only at entry-level positions, and even though they are the most qualified for the next level supervisor, you see very different patterns. So having that information really is one of the critical solutions to understanding where paid data exists so that we can then fix those problems.
Thank you. In addition to stronger penalties for gender discrimination at work, we need to offer solutions and resources that do help working families. Gender discrimination at work does take many forms, including pay discrimination, sexual misconduct, harassment, and abuse. One of my first actions once I came to Congress was to pass an amendment to the rules package that helps to prevent the misuse of non-disclosure agreements for workplace harassment and assault. I want to talk about measures like secret settlements and mandatory arbitration that are used to silence victims of gender discrimination. Ms. Goss-Graves, could non-disclosure agreements and mandatory arbitration be used to silence or pressure victims of pay discrimination? And if so, how do we prevent that?
Yeah, I mean, discrimination thrives in the dark, and that is one of the things that we have seen over the last year with Me Too going viral and Time's Up. We've seen a lot of attention around the really serious harm of non-disclosure agreements and forced arbitration and what that has meant. It makes people feel isolated. They think that they're the only one who's experiencing this sort of discrimination, and it allows an employer who's doing the wrong thing to continue to do it in the dark. You know, one of the things is, there is a longstanding bill called the Arbitration Fairness Act that would actually say, you can't force people into these secret settlements. You can't force people into this mandatory type of arbitration. You know, many people, it's a condition of employment, right? The idea is like you start this job, you sign this paperwork, and in that paperwork, you have no idea you have signed away all of your rights to be able to have your day in court, so to speak, or sometimes tell anyone about the discrimination that you've experienced. So that has to change.
Thank you. Yesterday, I stood with many of my Democratic colleagues to introduce the Family Act, which would ensure that workers have access to paid family leave and medical leave. How would enacting the Family Act affect the gender wage gap, Ms. Goss-Graves?
Well, we know that there's a motherhood and caregiver penalty, right? And one of the things as the transition to parenthood is that you're already making less, and so many people do not have access to paid family and medical leave. So having a national standard that says that people could actually do what people are doing, which is both working and care and have the time off they need to care for themselves, to care for their family members in those serious situations, is critical. And we look at it as a suite of issues that need to happen really all at once. It is overdue to finally raise wages, including tipped workers, to finally have paid family and medical leave, to finally ensure that people who are working aren't experiencing discrimination in the same job, and to have things like access to childcare and other work support so that people can do what they're doing, which is engaging in work and care.
Thank you so much. Thank you, Madam Chair.
Thank you, Representative. We have now concluded member questions. I want to remind my colleagues that pursuant to committee practice, materials for submission to the hearing record must be submitted to the committee clerk within 14 days following the last day of the hearing, preferably in Microsoft Word format. The materials submitted must address the subject matter of the hearing. Only a member of the committee or an invited witness may submit materials for inclusion in the hearing record. Documents are limited to 50 pages each, and documents longer than 50 pages will be incorporated into the record via an internet link that you must provide to the committee clerk with the required time frame. Please recognize that years from now, the link may no longer work. Again, I want to thank the witnesses so much for your participation today. What we've heard is very valuable. Members of the committees may have some additional questions for you. We ask the witnesses to please respond to those questions in writing. The hearing record will be held open for 14 days to receive those responses. And I remind my colleagues that pursuant to committee practice, witness questions for the hearing record must be submitted to the majority committee staff or committee clerk within 7 days. The questions submitted must address the subject matter of the hearing. And I now recognize the distinguished ranking member of the Workforce Protection Subcommittee, Mr. Byrne, for the purpose of making a closing statement.
Thank you, Madam Chairman, and let me congratulate you on this hearing. You've done an excellent job, and I appreciate your
Thank you,
leadership.
Representative.
When I think about this issue, I think about my grandmother. My grandfather was shot and killed when my mother was a baby. My grandmother went to work in the early 20s. Imagine the workplace of the early 20s for a woman. It wasn't just equal pay. Many jobs they wouldn't even let her think about applying for. And then my mom had to work too, and she was a bookkeeper. She may have had marginally better environment than my grandmother, but not much, just to be honest with you. My wife works. I would say she has a much better environment than my mother worked in. But still, as some of you have talked about today, we haven't gotten to the point where we've gotten exactly where we need to go. But when I think about this most, I think about my 2 daughters and my daughter-in-law, all of who work, and a 2-year-old granddaughter. And we want for those young women, and that little girl who will grow up to be a young woman, the workplace where they're paid for the true value of what they provide. Everybody on this committee wants that, everybody. The question is, how do we get there? I just got to say, I've looked at this bill, and I've listened to Ms. Olson with her substantial expertise, and it looks like it was written by and for the plaintiff's lawyers. That's what it looks like. And I practiced this area for a long time myself. I want something that's really going to help women, not something that's really going to help lawyers. And I think if we work together on this and come up with a bipartisan bill, which this is not, then we actually could improve the environment for those young women in my family. So I hope over the next several months we can do that important work, because at the end of the day, we should be about the people and not about the process. With that, I yield back.
Thank you, Mr. Byrne. And I now recognize the chairwoman of the Workforce Protection Subcommittee, Ms. Adams, for the purpose of making a closing statement.
Thank you, Madam Chair, and thank you to our ranking member as well, and to all of you for your testimony, and to all of the advocates here in Congress and on the ground working to ensure equal wages for equal work. Now, throughout this hearing, we've heard how women, particularly women of color, continue to face gender-based wage discrimination even after 10 years of the Lilly Ledbetter Fair Pay Act and 56 years of the Equal Pay Act. So it's clear from the discussion today that we've got to act now. We can't continue to rob $5 billion each year from nearly half of our nation's workforce, shortchange families and children by financially penalizing mothers, and force women to work 10 years more or up to 23 years more for women of color just to be paid fairly. Congress has an obligation to pass the Paycheck Fairness Act and end gender-based pay discrimination once and for all. I would remind all of my colleagues on both sides of the aisle that if you are a member of the U.S. House, if you are a member of the Senate, if you're male or female, we get the same check. So we need to think about that. Most of us here have, well, everybody here has had a mom. You have one or you've had one. And most of us, or many of us, have had sisters, or we have sisters and nieces and daughters and wives. So I just can't imagine that we would not advocate for them to be paid less for the same work just because they're women. So I want to thank all of you again. I hope that we can maintain a system where your gender does not have to determine your salary. The discussion today was an important step toward ending that shameful reality, and so I look forward to helping to shape an America where everyone receives equal pay for equal work. Thank you. Thank you,
Thank you,
Madam Chair. I yield
Representative
back.
Adams. I now recognize the distinguished ranking member of the Civil Rights and Human Services Subcommittee, Mr. Comer, for the purpose of making a closing statement.
Thank you, Madam Chair. I want to thank the witnesses for a good discussion today, and I want to thank our members for asking some really important questions. Ms. Olson, I especially want you to know how much your expertise shed light on this bill in particular. This is an important issue, but this is a legislative hearing. Your presentation of opportunities and shortcomings was particularly constructive, so I thank you for that. I'll be brief, but I want to emphasize again that women are changing the workplace for the better, and as the economy continues to improve, those contributions are going to become even more important. Thank you again for being here, and Madam Chair, I yield back.
Thank you, Mr. Ranking Member, and I now recognize myself for the purpose of making my closing statement. I want to thank the witnesses again for being here, for your valuable contributions. Today, women make up nearly half of our workforce. 64% of mothers in the United States are either the sole family breadwinner or a co-breadwinner. Their wages pay for rent, groceries, childcare, health care. Closing the wage gap is an economic imperative. It's good for working families, and it will help lift families out of poverty. Today's hearing on persistent gender-based wage discrimination addresses the very injustice that is facing millions of working families. Our witnesses described how insufficient enforcement and loopholes in the Equal Pay Act and the Title VII of the Civil Rights Act result in barriers to detecting wage discrimination and to holding employers accountable. We heard how gender wage discrimination has far-reaching and long-term effects for our economy, our children, and our families. Most importantly, we heard how Congress can provide workers with the tools they need to close the gender pay gap and achieve wage equality by passing the Paycheck Fairness Act. By addressing the problematic loopholes in current law, by empowering workers to better detect and combat wage discrimination, and by creating mechanisms for better pay data transparency, we can restore the original intent of the Equal Pay Act. And finally, after all these decades, make equal pay for equal work a reality. There being no further business, without objection, the committee stands adjourned.